Guwahati Lottery. Lottery will find at page 21. Specifically said that it appointment application are invited from eligible candidate not exceeding 56 years age with requisite qualification for filling up the following post on deputation basis under DRT Guwahati, last date is so. We are concerned with section officer. Only Lordship, the condition that is Lordship will found at the second column, note number 2. Note 2 in the second column, Lordship. It said that for the post of section officer, departmental candidate having requisite qualification shall also be considered along with the outsider. And in case the departmental candidate is selected, the post will be treated as have been filled by promotion. Now, the tribunal allowed the OA simply on the ground that treating that one who is appointed in a DRT Cuttack will also be a departmental candidate since he's come under the Ministry of Finance. And other is the analogy was appointment given to one K. Mukherjee. That is completely different lordship. So on that basis, the tribunal lordship kindly see section 3 of the Debt Recovery Tribunal Act.
Recovery of debts due to bank.
I have extra copies, lordship. Lordship may come to section 3. Establishment of tribunal and appellate tribunal.
Yes.
The central government shall by notification establish one or more tribunal to be known as the Debt Recovery Tribunal to exercise the jurisdiction. This is important, Lordship. Powers and authority conferred on such tribunal by or under this act. Then subsection 2, Lordship. The central government shall also specify in the notification referred to subsection 1 the areas within which the tribunal may exercise jurisdiction. So it's a territorial jurisdiction that has been restricted, Lordship. So the DRT Cuttack cannot be can have a jurisdiction over the DRT Guwahati, Lordship till 2018, Lordship. Till 2018, Lordship, respective DRTs were to appoint themselves, except gazetted officer, Group A. Now they are under every tribunal is under the Debt Recovery Appellate Tribunal, Kolkata. That is by the subsequent rules framed in 2018. So this appointment is of 2017. So he can, Lordship may kindly come to his appointment, Lordship, page 22. His appointment order. Vansidhar Mahapatra, assistant of DRT Cuttack, is hereby. Page 22, Lordship. By the approval of Honorable Presiding Officer of this tribunal to the post of section officer in the payment of so-and-so, revised so-and-so for a period of 3 years on deputation basis or until further order, whichever is earlier. Now, Lordship, come to the next page, Lordship.
You are saying that the appointment of section officer in Debt Recovery Tribunal Guwahati was made by Odisha.
No, made by Guwahati. This order is issued by Guwahati. He was working at Odisha. He came to Guwahati on deputation. He came to Guwahati.
No, you are showing us section 3.
Yes, Lordship, section 3.
Why?
Because the advertisement is used by DRT Guwahati. And that was specified that in the advertisement that it will be on deputation. So the one who is working in DRT Cuttack cannot be within the same departmental candidate. That is our case, Lordship. He cannot be the departmental candidate from Guwahati. That is our case, Lordship. He is working here as on deputation basis. And he exercised option and he has drawing deputation allowance, Lordship. Page 23. Everything is apparent, Lordship. Clear, Lordship. There is no doubt about that.
I'm not interfering, Lordship. That amount has been, he was asked to report, he returned.
That
it
is
back.
after the tribunal passed order, Lordship.
Some proceeding was also initiated in his team.
Lordship, Miss kindly go through page 23, Annex 3. Exercising option to draw the deputation allowances plus scale of pay of the post in the
But,
parent cadre.
Mr. Chakravarti,
Lordship.
in a debt recovery tribunal,
Lordship.
when they are referring to department, is it not Ministry of Finance?
That's true. But that cannot be, that wider interpretation cannot be given, Lordship. Because Lordship may kindly see that there is a specific rule for the respective DRT.
No, you see, I'll tell you why I'm asking this. Even whatever recruitment is being done in the district judiciary or in the establishment of the deputy commissioner, district establishment rules. Supposing they are asking for a for appointment to a post of LDA, they will say that any candidate can apply who is working in any establishment as in the rank of say LDA. So even if it is for Guwahati, you will find people applying from Dibrugarh because it is the state ultimately who is the who's their
But this-
master.
This advertisement is specifically written, Lordship, on deputation basis. And he exercise option. He was taking deputation, Lordship, moreover, Lordship, while working here. I know. Lordship, page 43 will make it clear, Lordship. After the 2018 rules came, Lordship, all the section officers are clubbed together and shown at a total in the schedule, Lordship. Page 43. This is after the 2018. Now everything comes under the DIRT Kolkata, Lordship. You will find the total strength has been given. What in Guwahati, Cuttack, then Hyderabad, Siliguri, Visakhapatnam. All come under the DRAT Kolkata. Prior to that, it was only respective DRT has to issue advertisement. There has to appoint, Lordship. And moreover, Lordship, we'll find it.
Have you seen that order of this court on 22nd June?
22nd June. Yes, Lordship.
You are supposed to produce the records.
Regarding that K. Mukherjee, Lordship,
Yes.
his appointment. Yes, Lordship, I have that.
notification,
regarding lordship.
section 3, you just.
This, that was furnished, perhaps this is in the record lordship, I produced on the other day lordship, by which the DRT Guwahati was constituted lordship.
Section 3 through notification.
Section 3 notification, yes, lordship.
And one more, the official records to be produced
This is
regarding that outsider, ward or outsiders, which you have given in the advertisement.
This is section 3 notification lordship. This was perused on last occasion.
We have it. Yes, available.
So,
Yes, sir. What about this salary, payment of salary?
lordship, that you have released.
That is being released.
One more aspect, lordship. While working at DRAT Guwahati lordship, he applied for for the Armed Forces Tribunal at New Delhi lordship. At that time, he sought NOC from his parent, that is from DRT Qatar. And we wrote to DRT Qatar.
It's okay if till date he has not been, his premises has not been accepted.
Lordship,
He's on deputation still.
still the.
Obviously,
So lordship will issue notice and
See, at the direction of Procedural Court, we file our affidavit also. But see, initially, he was, admittedly, he was working in the DRT Cuttack. When advertisement was floated by DRT Guwahati, he applied through proper channel and he was selected. However, he was appointed on deputation. Lordship, may please to see my affidavit also. It is not the case of the petitioner that I was not working in DRT Cuttack. Their contention is that both the tribunals are different. And Lordship, section 3 will not come into play because section 3 says about the territorial jurisdiction of the tribunal. And the notification which was produced by me, Lordship, it is said the place on which the tribunal is situated, Guwahati, then area of jurisdiction is state of Meghalaya, Manipur, Mizoram, Tripura, Arunachal Pradesh, and Nagaland. This means for the territorial jurisdiction of the tribunal for considering the cases arising out of different issues laws. It is nothing to do with the appointment and others.
No, it is just like cat, you see, unless
Yes.
there is a common cadre, then all of them for the purpose of employment are treated
No, no,
differently.
Right, Lordship, may please to see page 21. Second column.
Hmm.
Lower division clerk. Lordship, may please to see the note. He applied for the section officer. He was working as LDA, LDC in Cuttack Lordship. Note 2, for the post of section officer, departmental candidates having requisite qualification shall also be considered along with outsiders, and the case as the department candidate is selected, the post will be treated to have been filled by promotion.
So you see, one person is from on deputation from, let us say, in this case, let us say he has come from Kerala. His what you call his substantive posting is at Kerala. I'm just giving an example. Now, when as per this advertisement, in the supposing he is appointed in Calcutta, and this says that departmental candidates would be treated as promoted. So you see, it can't be that in the in your parent what you call cadre, you'll be treated as promoted.
Lordship, all the tribunals are the Ministry of Finance, Lordship.
No. You see, now it has been shown that now they have a common cadre under DRIT Calcutta. So now for the 6 different tribunals or 7 different tribunals, there is a common cadre.
It was made in 1988, Lordship. Subsequently, a common cadre was created. But before that, Lordship, all the tribunals are there having their own.
So it will be independent. Once there is independent, the question of promotion will not be there because he's from deputation.
Lordship close to, and Lordship may please to see. Page 53. Lordship will come to page 56. That will clear. My case was recommended by the DRT, hearing officer DRT to the chairperson of the Eastern Appellate Tribunal, Calcutta, Lordship. This will clarify the everything, Lordship. Married, Lordship. Page 56.
56.
Page Annexure 8. Sri Bansidhar Mahapatra, section officer of this tribunal, has submitted an application praying therein for consideration of his appointment to the post of section officer as promotion with effect from 2017. In view of this, his selection and appointment to in the post of section officer as departmental candidate in this tribunal as per recruitment rules published by the Gazette India on 15/11/2001. The above recruitment rules prescribe that in the event of consideration and selection of a departmental candidate in the post of section officer, then it would be treated to have been filled up by the promotion. In this connection, Sri Mahapatra has submitted that in a similar situation, the section officer from DRT Calcutta, Sri K. Mukherjee, has been selected for the post of recovery officer in DRT Guwahati and appointed as recovery officer in DRT Guwahati with effect from 15/7/2013. And his appointment to the post of recovery officer has been treated as promotion with effect from 15/7/2013. He has requested for consideration of his appointment to the post of
Mr.
section.
Kyal, we will have to hear it. There is a reason for it. Come to page 58,
Lordship.
last paragraph. In this connection,
In
we
this
mentioned that
connection,
after notification of 8/6/18 of the recruitment rules, the undersigned ceased to be the appointing authority. After so and so, it is submitted. Mahapatra has been appointed prior to 8/6/2018.
Yes.
The
yes,
new
Lordship.
recruitment, therefore, his appointment to the section officer will be treated as promotion with effect 20 to 2017.
Yes, Lordship.
So that is the recommendation.
Yes, he has
So-
made the recommendation, Lordship, because after 2018, he ceased to be appointing authority in case of appointment, Lordship.
Correct.
A combined rule was published in
Correct. So
2018.
the correctness of this has to be seen. He was promoted, he was appointed in 20 to 2017.
Yes, Lordship. That is,
So that time it was a different establishment.
no, Lordship, our case is that one similar situated person, he was from, if it is say, Lordship, then the appointment of K. Mukherjee was also illegal.
No, that we won't say, but once assuming Mr. Chakravarti is right, and we arrive at a finding that this could not have been done. So we will say that in this case it will not be done because even if there is
No,
a
no, no.
illegality committed,
No, Lordship.
negative equality will not
No,
be.
there is no question of illegality committed, Lordship. This is the advertisement says about that, Lordship.
No, we'll examine it.
And Lordship,
We'll give a
another
short
thing,
date for hearing, but
But
we'll
that
have to
is-
hear it.
Lordship, another thing, during pendency of the case,
Hmm.
the petitioner was asked to join his parent candidate. Then again, the Lordship may please to come to page
It has been
180.
withdrawn, now he is working here.
Page 183.
We should root because that is already covered. If you send it to him.
Okay,
Yes,
we'll,
Mr.
we'll,
Kyal, what you are saying something?
Yes, sir, page 183. During pendency of the case before the tribunal, I was relieved. Then I filed representation before the DIT Calcutta. Then Lordship order dated 12/5/2023 was passed.
Yes.
Paragraph 2. In view of the above, Sri Bansidhar Mahapatra is posted in DRT Guwahati on the same position on which he was relieved with immediate effect till final decision taken by DFS New Delhi or the DRT Calcutta, white office dated so and so, posted in passed by the Honorable Chairman DRT Kolkata, and his pen allowance will be paid by DRT Guwahati so and so. So he is still continuing as a section officer in Guwahati also.
Yes.
Was a matter for hearing, but there may not be,
Hmm?
the tribunal's order may not be stayed.
No, that promotion has to be stayed. Because if he's treated to be promoted for that
No, Lordship,
purpose,
only direction was given to them, Lordship.
so that will not create any right in favor of the.
Lordship, that will again, they will pass order relieving me from the tribunal. Lordship.
That
You don't
status
wait.
person today, he's working, will not disturb him.
You
Lordship.
don't
But
disturb him.
he'll be on
Because we'll
deputation
give
basis.
a short date for the hearing. We can see that he'll not be relieved. No? Status quo is. maintained. But this will- it should work.
Mr. B. Chakrabarty,
Lordship.
learned CGSC for the petitioners. And also Mr. S.C. Kyal,
Lordship.
learned counsel for the respondent. By filing this repetition, petitioners have challenged the order dated 24/4/2023, passed by the Central Administrative Tribunal, Guwahati Bench, in OA number 0404/375/209, wherein the learned tribunal has directed the writ petitioners to make appointment of the respondent as section officer as an appointment on promotion and not on deputation basis. Next period. The grievances of the respondents is based on the note number 2 of the advertisement, whereby it provides that for the post of section officer, departmental candidates having requisite qualifications shall also be considered along with the outsiders, and in case a departmental candidate is selected, the post will be treated to have been filled by the promotion. Having considered the
You have to say accordingly, he claims to be a promotee, not a. Claims to be, respondent claims to be a promotee. It is his claim.
and accordingly, just continue. The respondent claims to be a promotee. Please stop. Next para. Having considered the submissions advanced by the learning counsel to the parties, we were of the view that the matters request detailed hearing. Please stop. In view of the above, issue rule returnable by 3 weeks.
You suggest a date? When do you want?
Okay, first-
3 weeks would be okay?
Lordship.
3 weeks would be okay?
Yes, Lordship, we have already filed our affidavit. Leading case is ready for hearing.
Without requiring the text, petition to text us.
Without requiring the petitioners to take formal steps, as the learned counsel for the respondent has already appeared and filed his affidavit in opposition.
Lordship.
This time. Next para, in the meantime, status quo assumed today shall be maintained.
Lordship.
Deeply obliged.
List
If it's
this,
in the matter of
list the matter for hearing
7th September. Lordship.
7/9/2023.
Lordship, let it be on 12, Lordship, 12 or 14.
14 Lordship.
14/9/2022.
Deeply obliged. It's a long holiday, I think, over.
Yeah, returning your document because we have it here.
Lordship. Number 2.
Made. This matter, my lord, relating to family pension to the petitioners, my lord. The petitioner number 1 is the widow of the deceased pensioner, my lord. And petitioner number 2 is the daughter of the deceased pensioner. The pensioner, my lord, who has retired on 31/1/2004, my lord. And my lord, at the time of retirement, he had submitted a family declaration, my lord, which is not correct, my lord. And the authorities have, my lord, the declaration is at page, my lord, 30, my lord. The authorities has, my lord, remarked that he has 2 wives and he has more than 1 wife, and the first wife is missing since in the remarks column, my lord, at page 30, my lord. And his declaration dated auto is under continuation, wife dispute, my lord. For the dispute of the wife, my lord, the family pension was not sanctioned, my lord, to while the pension was finalized, my lord. My lord, page 29, my lord, the part 3 of the PPO, my lord, which is clearly that there is no family members, my lord. Thereafter, my lord, the petition, the deceased, my lord, pensioner submitted an application, my lord, at page, my lord, 34, my lord. That application, my lord, along with correct family declaration, my lord. That declaration is at page, my lord, 36, my lord. And an affidavit was also, my lord, shown by the deceased pensioner, my lord, stating the names of the family members, my lord. But this, my lord, this application was not considered, which was submitted after retirement, my lord, on 11/10/2004, my lord. This was not considered, my lord. And my lord, thereafter, my lord, when the pensioner died, my lord, in the year 2017, my lord, this petitioner number 1 submitted an application, my lord, before the authorities at page, my lord, 10, my lord, at an exact 10, page 45, my lord.
No, but your marriage is second marriage,
Second marriage, my lord.
then you are not entitled.
My lord, specific, my lord, there is, my lord, railway recruitment rule has specific rule, my lord, for giving the family pension to both wife, my lord. My lord, I have quoted the rule, my lord, at page 19, my lord. 7 rule, sub rule, my lord, 7(1) of rule
No, you see,
75.
under the, you are a Hindu.
Yes,
So the second marriage is void ab initio.
yes, my lord.
So the question of second wife will never arise.
But my lord, this rule, my lord, has specifically stated that both wives are entitled. My lord. Page 19, my lord, I have quoted the rule, my lord. Where the family pension is railway recruitment family pension, my lord, something, my lord, different from the CCS pension rules, my lord. This clause is there, my lord. For where the family pension is payable to more widows than one, the family pension shall be paid to the widows in equal share. On the death of a widow, her share of the family pension shall become payable to her child, eligible child, provided that if widow is not survived by any child, her share of the family pension shall not less but shall be payable to the other widows in equal share. Or if there is only one such widow in full. My lord, what happened, well, after the retirement, first wife died, my lord, in the year 2004 itself, my lord. And now she is the only surviving widow, my lord. And my lord, as per this rule, my lord, she is entitled, my lord. And thereafter she approached, my lord, the my lord, Honorable Kate, my lord, Central Administrative Tribunal, Guwahati, my lord. And order was passed, my lord, at page 52, Annexure 16, my lord. My lord, where it has been specifically directed, my lord, page 62, my lord, 61, last page, my lord, last para, my lord, 9. Para 9, by accepting the above submission of the Land Council for the railways, the respondent 2 is directed to consider and dispose of the pending representation dated 26/2/2009. In the light of sub-rule 7 of Rule 75 of Railway Service Pension Rules 1993 and the decision of the Honorable Madras High Court in D. Kurubama Supra, as quoted above, bypassing an appropriate orders after affording the applicant an opportunity of being heard, my lord.
You are reading which page?
My lord, at page 62, my lord. 61, last page, my lord. This is the first order of the Central Administrative Tribunal, my lord. Directed to dispose of the representation, my lord, in the light of the sub-rule 7 of Rule 75 and in the light of the judgment, my lord, rendered in D. Kurubama and Supra, my lord. My lord, this judgment, my lord, as per this judgment, my lord, second wife is also entitled, my lord, for family pension, my lord.
You have a copy of the judgment?
Yes, my lord, I have copies, my lord. My lord, page 8, my lord, clause, my lord, paragraph 12, my lord. The only substantial question of law that arises for the consideration in this appeal is whether the appellant, second wife of the deceased employee, is entitled for family pension and other retirement benefits. This is the substantial question of law, my lord. And my lord, this is quoted, my lord, and paragraph 14, my lord, then, my lord. A bare reading of the above rules would make it clear that family pension is payable to more than one widow in equal share. Even under the proviso to the said rule, it is if the widow is not survived by any child, her share of family pension shall not lapse, but the same shall be payable to the other widows in equal share. Or if there is only one such widow, in full to her. Even though first wife died, her legal heirs are entitled for family pension. Thus, as per the provision to the rule, first step plaintiff is entitled for family pension. In a similar circumstance, the Union of India versus Jayantia Bhai, the division bench of High Court of Bombay has considered the scope of Section 11 of the Hindu Marriage Act and has held that Rule 75 is independent of the Section 11 of the Hindu Marriage Act. And therefore, under the rule, the second wife is also entitled family pension. Paragraph 9 of the High Court of Bombay has held, this is the rule, is quoted paragraph. What we find is that Rule 75 provides for grant of pension even to the second wife, widow of a deceased railway servant along with the first wife. In our opinion, provision of Rule 75 made by the Indian Railways cannot be held to be in conflict or contradiction with Section 11 of the Hindi Marriage Act. On contrary, in our opinion, for achieving the constitutional goal as aforesaid, even for unfortunate second wife, widow, Rule 75 provides for grant of family pension to her for her survival in life. At any rate, it must be seen that by virtue of Rule 75, payment of pension to two wives is required to be made in equal share, which clearly shows that there is no burden on the Treasury or the Indian Railways by inserting the said novel idea. There is no reason for such to hold that Rule 75 violates Section 11 of the Hindu Marriage Act, or that is contrary to the Hindu Marriage Act, since it does not even remotely provides for any contradiction or interdiction therewith. We therefore hold that 75 has been brought in the rule book by Indian Railways fully in consonance with the aforesaid constitutional provisions. And there is another, my lord, judgment was quoted, my lord. Union of India versus Sushila Devi, my lord. This has also held that, my lord, second wife is entitled, my lord. Paragraph 15, my lord. In Union of India versus Sushila Devi cited Sutra, the High Court of Calcutta has considered Rule 75 of the rules and has held that second wife is also entitled for family pension. But the first appellate judge has erroneously come to the conclusion that under Section 16 of the Hindu Marriage Act, the second marriage is void, and hence first appellant is not entitled for family pension as held by the division bench of the High Court of Bombay. Rule 75 is independent of the Hindu Marriage Act.
Will issue a notice then?
Lordship,
There is a judgment of Madras High Court will.
Lordship. Pursuant to the Honorable Kate's order, Lordship, a speaking order was passed. And this speaking order was upheld by subsequent order of the Kate Lordship. Page 64, the speaking order is page 64, Lordship. The deceased has not made any declaration regarding Lordship, the petitioner or any children from her. 64 is
Just 1 minute.
64.
Just 1 minute. Where is the service book of giving declaration of the number of family members? That is page 30.
Yes, my lord, page 30 is my lord, at the time of retirement, my lord, which is, my lord, not accepted by the authorities. My lord. As remarks column says that, my lord. Thereafter, my lord, another declaration was submitted, my lord. That is, my lord, at page, my lord, 36, my lord. This was the correct declaration, my lord. This was submitted, this was countersigned by the authorities.
Now, in this page 30, who is number 1, 2, and 3? Who are they?
They are the
First
earlier, my lord, first wife and her two sons. My lord.
Her two sons.
Yes, ma'am.
They have not been made parties here.
No, but they are not, first wife died, my lord. And other sons, my lord, they are not entered, they have become older, my lord, more than 25 years.
No, but you are seeking, you see, you are seeking a declaration in form of a pension. You are seeking a declaration that you are the second wife.
Yes, ma'am.
Does the children of the first wife, they don't have a right to object whether you are in fact the second wife or not?
My lord, they are not made parties. My lord, as my lord, they are not entitled, my lord, they have aged, my lord, more than 25 years.
No. You see, just think of a situation where where a person is there and somebody is declared to be his mother.
Yes.
So will that person not have a right to say that my father never married for the second time? You are claiming by way of a direction for a pension. You are in fact seeking a declaration that you are the second wife.
Yes, ma'am.
So are you not required to make the family members a party?
My lord, who is entitled, he is also a party, my lord.
No. It's a declaration. You see, a declaration of a what you call a character is a declaration in rem. It's not a declaration in personam. When somebody comes and says that I am his wife, and the court accepts it, this is a declaration in rem. It's not that this is a litigation against A, so therefore it is operative only against A. A declaration of status is a declaration in rem.
Lord, it had two sons, first wife, two sons, my lord. My lord, in that case, my lord, Pintu Rai, whereabouts of Pintu Rai is not known now, my lord. And Prabhat Rai
That
is
won't
there.
help you.
Prabhat Rai is there, my lord.
That won't help you. You will have to, when you are seeking a declaration, you will have to find them out. If somebody is your son and you don't know where is he, or somebody is your daughter, you don't know where is he. He becomes your stepson or stepdaughter.
Stepson, my lord. Stepson.
Can you claim that you don't even know
My lord,
him?
one thing is there, my lord, the name of the Pintura is not mentioned in the second, my lord, the declaration, my lord. He is, my lord, he is not known, whereabouts of his is not known, my lord.
That won't be a defense.
So his name was not declared in the second, my lord, declaration, my lord.
I may not speak to my uncle with whom I have a fight. I dislike my uncle. I may not speak to him, but I can't say that I don't know him. He's a family member.
My lord, I know him, my lord, but he is whereabouts is not known, my lord. Prabhat Rai is there, my lord. I can make party. And his name was also not mentioned in the second declaration. Pintura's name is not there.
Has not made any declaration lordship during the whole service period and in the last declaration also before his retirement in 2003 lordship. Their name or their children's name were not declared in their,
He did not declare.
no lordship. In the speaking order, also, it is clearly stated. And petitioner submitted application for pension claiming as a legal heir of the deceased only in 2019 lordship. Though she claimed
Prior
that,
to that, my
though
husband,
she claimed that they are
How do you claim the marriage took place?
in 1983 lordship, 25 to 1983,
83.
83,
more than 34 years of.
No, but how was the marriage solemnized?
yes lordship. And during this long period, he has not declared anything.
Lord, she had 4 daughters and 1 son, my lord.
No, that is okay. But how did you, how was the marriage contracted?
As per rituals, my lord, marriages. We can do that.
What's that? You see, I have a question for you. Notice, since the husband is dead and his children from earlier marriage are not before us, that means we cannot have a statement of a person who is dead. Correct?
Yes.
And this situation is envisaged under section 32 of the Evidence Act. 32 says cases in which statement of relevant fact by person who is dead cannot be found, etc., is relevant. Clause 5 of that says when a statement relates to existence of any relationship by blood, marriage, or adoption between persons as to whose relationship by blood, marriage, or adoption the person making the statement had special means of knowledge, and when the statement was made before the question in dispute was raised. Therefore, when your husband at the time of leaving service gave a declaration that he had only 1 wife and 2 children and excluded you, that becomes the last statement of your husband.
My lord, as per last declaration, my lord, and the application, my lord, at page, my lord, at page 34, my lord, is the application, my lord, which was submitted, my lord, in the year 2004 itself. My lord. In that application, my lord, and the next, my lord, that family declaration, my lord, and also affidavit at page 38, my lord. These 3 documents, my lord, clearly stated that the petitioner number 1 is the widow, my lord. Here, my lord, may I read page 34, my lord. The application filed by the husband, my lord. Subject inclusion of my second wife, Srimati Anjali Roy, in pension case as my first wife, Subha Roy, expired on author. I beg to state that I was retired from railway service on 31/1/2000 4 on superannuation as the capacity of ex senior gateman under SSC so. Due to wife dispute, I could not submit joint photo at the time of my retirement. That is, only self pension has been sanctioned. That's my first wife, Subha Roy, who expired on 26/2004, and my second wife, Timothy Anjali, this is the petition number 1, is residing with me since my date of marriage with her on 25/2/1983. In view of the above facts, I would pray, Your Honor, to kindly include second wife in my pension family declaration and also sanction family pension in favor of second wife, so that in case of my death, she may draw family pension from UBI Sorgula branch, where I am drawing pension against SB account number 7. The affidavit was also thrown by my lord, this pensioner, my lord, at page, my lord, 38, my lord. Clearly, my lord, the relations are there, my lord, stating, my lord. And my lord, from the documents, my lord, submitted by petitioner number 2, my lord, his her caste certificate, and my lord, the unemployment certificate, all these things show that, my lord, the Anjali petitioner number 1 is the wife of the late Sanjit Rai, my lord. These documents are there, my lord. Another thing is that, my lord, this pensioner, my lord, was drawing the pension at the joint account with, my lord, petitioner number 1, my lord. That is at page, my lord, 42, 43, my lord. This is the joint account, my lord, wherein, my lord, the pension was drawn by the deceased pensioner, along with the petitioner number 1. Page 42, my lord. And the death certificate also speaks, my lord, about the name of the petitioner number 1 as a white, my lord. Death certificate is at page 44, my lord, and exam 9, my lord.
Devi, we are issuing a notice.
Yes.
Let them, we will file your response.
Yes, Lordship.
Mr. N. Hock,
K. Uddin.
A. Uddin,
K.
K. Uddin, counsel for the petitioners. And Ms. R. Devi Leonard, CEC appearing for the respondents. Keeping the issue of maintainability open for non-gender of children of the first wife as respondents. Come on. As the petitioner claims, petitioners claim entitlement to family pension, though petitioner number one is the second wife, claims to be the second wife of the deceased. The court is inclined to issue notice returnable in 4 weeks. Requisite extra copies of the petition be served on the runner CEC in course of the day. This after 4 weeks.
All right.
All right.
You file your response. You take this back. We'll.
Item number 3.
Yes, Mr.
May it please the lordships. All petitioner before lordships, all are joined as a casual labor in the year of 1988 to 1999, my lord. Under telecom district engineer telecom circle textbook, my lord. And thereafter, my lord, on 27/5/1996, they were granting in temporary status, my lord. And my lord,
BSNL CCC will appear.
BSNL received copy, my lord. Mr. Bibhas Pathak will appear. He's received the copy.
Who is there?
Mr. B. Pathak, Bibhas Pathak.
Mr. Pathak.
My lord, petitioner praying
Just,
before,
just.
praying before.
Yeah. Bench, fence sitter.
Yes.
We issue notice.
Yes. Your lordship, I think your fancitter's question is raised, my lord. I will satisfy the modus
No, it's
than
okay.
along with it.
It's okay.
My lord, fancitter will be raised if third party acquire the rights. We have the under right, under
No, it's okay,
fundamental.
but we will keep that.
My lord.
Uh,
I'm satisfied, my lord. I think the decision.
Mr. N. Bora, counsel for the petitioners,
My lord.
on appears and call for the respondents. Next paragraph. In view of the nature of dispute raised in this petition, comma, issue notice returnable in 4 weeks. Well, you just while keeping the issue of the petitioners being No, the issue as to whether the petitioners are fence
My lord,
sitters.
that is, my lord, that is.
No, we'll just note it.
Then my lord, I will satisfy my lord.
Issue notice returnable in 4 weeks. Requisite extra copies of the petition be served on the runner. Standing counsel for BSNL within 2 days. Next para. The pendency of the petition shall not be a bar for the respondent authorities to examine the claim of the petitioners and pass appropriate orders.
My,
This start for 4 weeks.
my, list, that may be fixed, my lord. Fix
I'm
a
not
date.
fixing a date right now. You make a
Otherwise,
mention if it doesn't come.
My lord, because of that, my lord, others are getting benefit, my lord, next, my lord. So, my lord, so that. may
Give a
be
date after 4 weeks.
Story, read by Winkle.
15/9.
March of less.
Then in the top also you write returnable on 15/9, not 4 weeks.
March of less. Mr. Bibas Patel, copy you start to the Mr. Bibas Patel. And he may be
You-
careless.
We were just remembering Rip and Winkle.
March of less.
Yes, Mr. Sen. This IA is for
Suspension of conviction. and
suspension.
Well, articularship page, last page 156 of the paper. Last page of the paper book. Page 156.
Yes.
This honorable court order, heard such and such. After hearing the argument of the learned counsel for both the party sides, we are of the opinion that paperwork will be necessary for appreciation of the argument made by the applicant counsel on the question as to whether one can be treated as an eyewitness in this case. It is the IA, my lord. Now, my lord, since our contention is since there was no eyewitness, my lord, that is why, my lord, on the basing of the PW1, the information,
But bullet was seized and what you call,
that is true, my lord. I am coming later on, my lord.
It was tested.
Well, it was tested, my lord. I am coming the later on ballistic opinion also. Now, articularship the PW1, my lord, evidence, my lord. For a moment. That was also, my lord, contradicted by the IO, my lord.
because what I find is that your only difference is that that it was not your quarter. The recovery was made outside the room of the quarter.
Well, it is the Caesar witnesses evidence also, and the carbine which was recovered, my lord, and the carbine was issued, my lord, and from the register of the issuing, my lord, carbine.
But for that,
That is a different, my lord.
for that, there are witnesses saying that you came out with the carbine.
No, my lord, no witnesses, no eyewitnesses. My lord, that is from the beginning PW1 made. None of the witnesses was eyewitness. My lord. Only in the judgment, my lord, itself, that only basing of the PW1, my lord, the informant.
It will be 1 or 3.
One man. Malad one man. Malad in the judgment also. Malad I am coming just later on. Malad for a moment. Malad I take a lordship page 8. Malad the evidence of PW1. Malad page 8. Malad. May I read? The incident took place around 6:45 p.m. on 7/10/2012. At the time of incident, my husband Nazrul Islam was posted at Kajalgaon. He worked as SB branch. We lived in a family quarter beside the SP office. We lived on the 3rd floor. Accused actually lived on the ground floor of the same quarter. My husband used to come home in the evening every day. And just at that time, I used to come down and bring his shopping bag in advance. On the day of the incident also, on seeing my husband stopping his motorbike, I came downstairs. My husband was climbing up the staircase and I was climbing down. Just then accused Atwar came out with a carbine in hand all of a sudden and shot my husband from behind. I screamed as he shot him. I rushed to my husband and after holding him, became unconscious. Accused Atwar ran to his quarters and closed the door. As soon as I got to hold of my husband, he told me twice that Atwar had shot him. The bullet entered through my husband's back and exit from his chest. When I regained my consciousness, I learned that my husband had died. Then I lost the Azhar. Now in the manner cross matter, we had been living in that quarter from one before the incident. Previously, we had lived in the quarter of such and such, Panbari in Dhubri. The accused worked in the Department of Police. I do not know what was his designation. Earlier, he had not had any acquaintance or visiting terms with my family. My lord, I am emphasizing this 4-5 lines, my lord. The building of our
You see,
quarter-
I'll tell you why I remember P23. Please come to page 23,
My lord,
last about 5-6 lines.
my lord,
There is overwriting on the last number 6 in the material exhibit 10.
my lord.
The countersign of the in charge not taken. The only person to whom arms and ammunition were issued put his signature. It is not a fact that material exhibit 1 was
Was
not
not
issued to Ataur Ali. So therefore, this bullet is
No, bullet, no, carbine, my lord.
carbine. It was allotted to Ataur Ali. That means the appellant.
No,
That
my-
is-
no. My lord, from the, my lord, if your lordship, I have seen the record also, my lord, it is 6-100, day 6, my lord. The carbine was recovered was 8, my lord. Now I take your lordship, my lord, ballistic opinion then. My lord, may my lord complete the. evidence of
Yes,
this?
yes.
Fourth line, my lord. Earlier, he had not any acquaintance or visiting terms with my family. I'm emphasizing this line also later on, my lord. The building of our 4-quarter had 4 straight. There were 4 quarters on the ground floor, the staircase on the side of the 4 quarters. I do not know who were there in the 4 quarters, but there were people there. There was no house or quarter near 4 straight building. The staircase was adjacent to the other quarters. There were people in the nearby quarters. I know them, but I do not know their name. It is not a fact that I did not stated before the police that while I was climbing down staircase, I witnesses Atwar shooting my husband from behind. Well, I am later on the evidence of IO. My husband did not work police SB branch. There was no weapon with him. All the residents in quarter were police personnel. I do not know if all of them had arms or not. There was a light in the staircase. There is a translation missing, my lord. I have checked the evidence, my lord. It was a suggestion, my lord. It is not a fact that there is a light in them. There was a dark. It is not a fact that accused did not shoot my husband. We had no quarrel with Atwar, my lord. This line and the no acquaintance with this, my lord. Why I am emphasizing, my lord, there is no acquaintance with or visiting with the family in the same quarter in spite of, my lord. There is no quarrel. Absolutely, my lord, under 300, my lord. Supreme Court and in the 300 also, my lord. Motive and intention is to be there. The prosecution side has absolutely failed to bring the malad in case of 30 conviction of 302 malad. Motive and intention is one of the essential criteria. No, there is no incantation. There is no fight between malad. Why should I shoot him, malad? That plea was taken, malad.
I don't know. A few days back, I read in the newspapers that in US, a man came inside with a carbine and shot at the young children. On a few months back. No, I don't know. I'm just saying. So the motive, if we try to find out, somebody is making a bomb blast somewhere. So
No,
motive,
there is a in that case, there is a conspiracy, there is a plan, my lord. That leads to intention, my lord. We made a plan. On those days, we made a firing or making a bomb blast. There is a long back plan, my lord, just step plan, my lord. Suddenly,
always that when the incident speaks of itself, then I don't think that motive is necessary.
One judgment of the Superman, I am careful later. I did not remember for how long I remain unconscious. At one moment I regained my consciousness, the next moment I lost my consciousness again. It is not a fact that my husband did not stay at that Atwar had shot me. When I screamed, the resident of the quarters came, but it is not stated to see who came and how many people came. I cannot say how many people heard my husband uttering that Atwar had shot him. It is not a fact that Atwar had not killed my husband. It is not a fact that some police personnel had killed my husband. I do not know how to read English. I do not know who had written the Ezahar. Now, my lord, this evidence, my lord, PW1, my lord, the basing of her evidence, my lord, the conviction was made basically. Some other corroboration, they are not, no one eyewitness. Now,
No, same thing is by PW3 also.
no, my lord, no, that PW3, 4, my lord, they are, my lord, stated to be, my lord, they came later on, they have not seen the occurrence. Well, I'm reading
No, no,
their
I-
evidence
I'll
also,
show
my lord.
you.
Just I'm reading, my lord, the evidence of IO, my
No, come to PW3,
lord.
page 16 of the paperwork.
My lord.
On our query,
Well.
he told us that accused Atwar fired at him and he pointed the quarter of Atwar.
Atwar, my lord, my lord. My
So
lord,
even the dying, the man before dying told the PW3
Well.
that this is what has happened.
Atwar came out and he wearing black pant and t-shirt, he had carbine with him. He told his son that when I myself and when Atwar stayed of my quarter, after 10 feet, I heard the sound of first. Malad, he heard the sound of bullet, Malad. That means he was not present at that.
He was not present,
Malad,
but he heard from the dead person.
Dead part, Malad. Now the IO witnesses, Malad. These two witnesses, Malad, contradicted, Malad. Article, Malad, for a moment, Malad, the evidence of IO, Malad. Page.
Before that, before you come to IO,
Malad,
come to page 17.
Malad.
It is below about 7-8 lines.
Malad.
It is not a fact that I did not state to police that Nazrul Islam told us that Atwar had fired him. It is not a fact that Nazrul did not point out the quarter of Atwar, nor he was in a position to point out.
Yes, madam. I am kind. Before 5 line 1, hearing the scream, I came out and followed the wife of the Nazrul Islam. After getting down, I saw wife of the Nazrul Islam, Shah Jalal Sheikh, after 10 feet, 15 meters, other resident of the building assembled there. Well, he came later on.
He came later
Well,
on.
hard manner. He heard. Well, all the witnesses, manner, say he heard from others. Now, well, I take ownership the evidence of PW IO method. Well, just I'm page 47, my lord. Page 47. To the court, my lord. Your lordship in the middle part, to the court. PO is the front of the side of the court. PW1 did not state before me that she saw that accused fired to her husband when she was going downwards on the staircase. And in her evidence, he said, my lord, she said, my lord, he saw accused fired on board. The PW, just for a moment, I am pausing, my lord. Now, this normally, my lord, the counsel, defense counsel stated the IO, my lord. Merely, this is not a putting a sentence in the evidence, my lord. Just for a moment, my lord, I mean, just emphasizing these 2 lines, my lord. My lord, the incident took on 17th, my lord, August, my lord. My lord, the copy of the 161 statement, my lord, which was supplied during the trial 407 of the CRPC, my lord, and just 4 or 5 lines, my lord. The credibility of the PW's evidence. It is in a vertical line. Joakali 17-10-12 ইং তারিখ সন্ধিয়া অনুমান 6:40-6:45 মান বজাত মোৰ স্বামী মটৰ চাইকেলেদি আহি মটৰ চাইকেলটো বিল্ডিঙৰ আগফালে থৈ গ্ৰাউণ্ড ফ্ল'ৰৰ কৰিডৰেদি চিৰি বগাই ওপৰলৈ উঠি অহাৰ সময়ত গুলি ফুটার শব্দ এটা শুনা পাও মানে PW1 this is 161 but it is immediately on the next day matter মানে this evidence in so many cases after 6 years 7 years 10 years matter that is why the evidences are that is why the corroboration and the contradiction are came in the evidence এটা শুনা পাও মানে she heard the sound of bullet মানে it was immediately after some hours মানে মই সেই সময়ত মোৰ স্বামীৰ মটৰচাইকেলৰ শব্দ শুনা পাই স্বামী অহা বুলি মই ছেকেণ্ড ফ্ল'ৰৰ ষ্টেয়াৰ বাৰান্দাৰ ওলাই আহিলো গুলি ফুটাৰ শব্দটো শুনা পাই মই চিৰি দি তললৈ গ্ৰাউণ্ড ফ্ল'ৰত কৰিডৰৰ পিনে নামি অহাত দেখা পাওঁ যে মোৰ স্বামী আতৱাৰ আলী কোৱাৰ্টাৰৰ দৰ্জাৰ সন্মুখত চিৰিৰ তলত কৰিডৰত জখমী অৱস্থাত পৰি আছে Now, Mala, it is immediate the statement recorded under 161 Mala. Now, after 7 years, developed the case, Mala, I saw him that I have stated before the police. That also, Mala, that is why I am reading this vernacular. PW1 did not stated before me that he saw the accused person bullet when she was going towards the downstairs. Mala, it is not possible, my lord. My friend, if he in the third floor, I am in the ground floor. My friend coming downstairs, I am up. It's not possible to see. It's not a rational matter. That, my lord, that is why I'm emphasizing the 161 extended on the very next day it was made, my lord. And subsequently that they developed the case, my lord. That is why, my lord, the bullet, my lord, which was, my lord, emerged from the carbine, my lord. Now I take a look at the ballistic opinion. Now, the Supreme Court also opined in a case, my lord, the Supreme Court did not make an opinion on the merit of the ballistics opinion, my lord. Just for a moment, just 2, 3, 4 line, my lord, the evidence of PW17, my lord. The carbine which was recovered at the place of the occurrence, my lord, it was a different carbine. The carbine was issued in the register. It is also in the part of the, my lord, PW17, my lord.
17.
My lord. I am not giving trouble. Just I am reading the operative, my lord. PW17, page 49.
49.
My lord. One 9mm calibre carbine machine gun register number 16086-108, 1995, marked as Exhibit A in the laboratory. Now, my lord, 5, my lord.
Yes.
Now, 5, my lord. Exhibit A is in last 2 lines, my lord. Exhibit A is the 9mm calibre carbine machine gun, and it is a factory-made gun. Now, next page, my lord, 150. My lord, page 50. Exhibit C are 9mm into 19 calibre live cartridge. Exhibit D is a 9mm calibre fire cartridge case. Exhibit A has been tested fired in the laboratory. That is, my lord, the exhibit A is the, my lord, the 9mm calibre carbine, my lord. The test fire cartridge case of exhibit A have been compared with exhibit D, my lord, that is the 9mm calibre cartridge case. Under comparison microscope, the firing pin impression of exhibit D and tested fire cartridge case of exhibit A are found similar. Hence, it can be conducted that exhibit D was fired by exhibit A. Very well, my lord. Exhibit E is 9mm calibre fire bullet. Exhibit E has been compared with the test fired bullet of exhibit A. but due to some extraneous marks on exhibit E, opinion could not be formed regarding its firing. If fired bullet hits any hard substance, then extraneous marks can be found on the fire. Normally in the defense manner, cross manner, the forwarding letter along with the box was received by me is not submitted. I did not find any extraneous mark on the entry Curtis case exhibit D. I do not know if exhibit E was not fired from exhibit A. A is the carbine, E is the bullet, my lord. Assuming, my lord, that even though, my lord, I do not know if the exhibit, assume E is the bullet, A is the carbine. From the gun of the carbine of the exhibit A, that carbine was not issued to me, my lord. Well, the man had died at the bullet shot. That is true. Somebody have to, some bullet has emerged in the chest and back had gone backside. Well, that is why if it is in assumed, my lord, the exhibit E was fired from the exhibit A. Well, that carbine was not issued to me, my lord. And that apart, my lord, why I'm, my lord, I'm just reading one judgment, my lord. My 2019 6 SCC, my lord, 535, my lord. Para 18, my lord. My.
Which
My lord, para 18, my lord.
which witness proved this The exhibit 10. Who is the witness who proved exhibit 10?
Well, exhibit,
That carbine issue register.
well, it is. When I take a look, it's page 18, man.
Page
118. This is the, your lordship, exhibit 10, Mala. This is the registered Mala.
No, register I have seen.
Well.
Who has proved this? Which witness has proved this?
Perhaps it is. PW8,
PW 8.
Mala is PW5, man. Sorry, Mala, because he sees the turbine, man. He is a Caesar witness. Page 23. Page 23. The distance of the place of occurrence from my.
I'll tell you what has happened. I'm not sure because we. Can you come to page 51?
Right.
In this evidence of this PW5, there's a reference to overwriting.
Well,
Correct. Now come to page 51.
Well.
Second para. In this case, on receipt of copy of order, the reserve officer Jayaprakash Pandey and Zakir Hussain in respect of manipulation in the arms ammunition issue register. While Zakir Hussain was explaining that to the reserve officer, I was present. In my presence, Zakir Hussain had stated that he had not done the manipulation as to the carbine number issued to the accused Atwar Ali, and that the said manipulation was done in the court by the defense counsel.
that cannot be possible, Malad Mayor.
No, because you see,
Because
the,
Malad, I have the copy of the Malad that certificate copy. Malad, at that time it is offline, Malad. Not it is possible, Malad, because this registered book, Malad, kept under the custody of the police officer. It is on the record, Malad. It is not merely on the day of the evidence it was manipulated, Malad. It is exhibited by exhibit 10-1.
I've checked that there is manipulation. There is overwriting. Exhibit 10 in original, I've checked on the last occasion. There is overwriting. 6 was made 8 or 8 was made 6.
No, Mala, it is not 6. Mala, it is overwriting. There is overwriting 6, Malad, but it is not 8, Malad. It is maybe seems to be Malad 0. If your lordship, there is a no, it is not 8, Malad. It is not 8.
I've seen the original. Difficult to make out, but then there is overwriting.
Yes. So, Malad, it cannot be said is beyond reasonable doubt. It is a 6, Malad. It is apparent, Malad. So far, my eyesight is it is a 6.
But then there is overwriting. That's an admitted position. Now, who did it? There is one witness
not
saying.
admitted, Malad. Their stand is to Malad is the. Malad, even.
it's okay. I'm not putting any. I'm not giving any suggestions, but this is what has happened.
There should have been a complaint registered.
And PW evidence is said it is an overwriting.
No, but still, what has happened is that, notwithstanding everything, this witness also says in the last 2 lines of page 23, it is not a fact that material exhibit 1 was not issued to Atwar Ali.
No, it was my 313 malab stated mallet, the carbine, which was the bullet came out from that carbine mallet. I mean, when in 313 mallet, I have stated mallet, it was not issued mallet. Mallet, if your lordship space 53 mallet. Page 53.
Because we are not finding this case, appropriate case to release you on bail, but we may hear the matter on merit.
Page
We can give you an early hearing.
Page 53, mallet 8. During investigation, police had seized your carbine, the empty cartridge of the used bullet, and the bullet was fired at the deceased, and the ballistic examination of the aforesaid material showed that the bullet seized from the place of the occurrence, seized by the exhibit 2-3 respectively, were fired from the carbine bearing registration number such and such and such 108. What do you have to say on this? The said carbine had not been issued to me. Now, 9 mallet, evidence on records, next page mallet, shows that 9mm carbine having registration number such and such was officially allotted to you and was in your custody at the time of LS incident. What do you say? The said carbine was not an order to me and was not in my custody at the time of the incident. That 8 mallet. The carbine was issued mallet, that is the 6. Mallet, I have seen it is a 0, not even 6 mallet. Assuming mallet is an overwriting, apparently, but I have seen it is a 0. Perhaps my learned friend will also be agree mallet. This is the copy mallet, which is also in the report. It is 16086100.
Original is original. I've checked on the last occasion. I can take it out.
It is not at 8 as the carbine seized. The last digit.
I think I marked it. My corner. এই original to have 8 training with personally. No, it is 0. Perhaps I marked it on the last occasion, the pink color flag. I'm not very sure, but
No, it is.
not that. I can take out lordship. I remember.
It is.
দুটা 0 দিয়ে 8 হয় না? But then ইমান evidence আছে ক'ৰ পৰা apply কৰিব তুমি 1 to গুচালেও তোমাৰ টাইম দেখি আছো মানুহ এটা দেখিছে কাৰ্বান লৈ ওলাই আহে ওপৰলৈ যোৱা আছেতো বেলেগ coming out
So, not forward. Right there.
উলিয়াইছে চাগে, উলিয়ালে।
আরে উলাইছে।
কপি পাইছে না স্যার? আজি তেখেতৰ সিংগল বেঞ্চ আছে না দীঘল বেঞ্চ আছে মনত পেলাই দিবা হা আমি সোনকালে যাব বিচাৰিছো আৰু হা
Nice. PW9, I did not see the occurrence.
No, you see, still, Mr.
Even my lord, nobody, no eyewitness, my lord. And apart from my lord, the carbine which was issued, that was not that carbine from where the bullet but came out.
No, Mr. Hussain, you see, there are few things which.
1 years already behind the bar, my lord. Let
uh,
my lord
No, you can
make
fix a date for hearing, but still you are not inclined to give grant on bail. You see, the 2 or 3 things which are there. Come to page 26.
my lord.
Page 26, you will find that in the middle, when we found carbine inside the carton under a bed and 2 magazines, some loose rounds of suitcase, checking of carbine, we found 19 rounds of bullet attached to it. And there were 20 rounds of bullets in each of the 2 magazines in the suitcase. So one is missing otherwise.
My lord.
We made a search for empty cartridge and we found the same at the place of occurrence. The empty case was seized. The general impression is that the appellant was the perpetrator. Because there's another aspect to it. Let us assume that the entries in the book, this armory book is wrong.
Right.
We'll assume it that is wrong. But then you have been there's a signature of yours. So there should be another carbine which is available with you.
No, my lord, one carbine.
No. This 1806408,
My lord.
there's a manipulation, so that was not issued to you.
My lord.
Correct. So that is in your favor.
My lord.
But then what happened to your own carbine?
My lord, that is, his signature is there, my lord. In the material exhibit 10-1. It is owned
No,
by
no,
carbine.
no, that
It
is-
my signature is there.
No. That is a manipulated entry.
Well-
So that means whatever it be, 068, whatever it be,
Right.
one is allotted to you.
Right.
So if that is a manipulated entry, there should be another carbine with you. You're not getting my point. This was not issued to you.
Right.
Correct.
Right.
So, but then you must have one more. This is not issued to you, so therefore this is the other carbine, because there's only one carbine issued to you. So whether it is 0 or 6 or 8 doesn't make a material difference because that is a carbine which is seized from you. And that is showing that the discharge is made. The ballistic report says it has been discharged, and that bullet could not be traced out because of the fact that there's extraneous marks. And the witness says that extraneous marks is there when the bullet is hits something and then
Hard substance.
so it's not there. So therefore, we are not finding it to be a fit case to grant bail, but we can expedite the hearing. So you have made strenuous effort, but still 3 or 4 things I am.
Malad. Even Malad, the Malad judgment of the Supreme Malad, just one Malad.
Yes.
There are 18 men, 2019 6 SCC. Ashok Singh, Jayendra Singh versus State of Gujarat.
Para?
18 men.
Para 18.
2019 6 SCC.
This is 2019 6 SCC 535.
Mala. Para 18 Mala. The learned counsel appearing for the appellant mainly contended that fire bullet was not recovered and only empty cartridge mace made of bronze were recovered near the mango tree. Contention of the appellant is that since the fired bullet which caused fatal injury to the deceased was not recovered, the ballistic expert cannot give definite opinion as to which weapon was used to cause the fatal gun owned to the deceased. The learned counsel further contended that ballistic expert has stated that he only tested the fired bullet C2 from the rifle C1 and examined only empty bullet recovered, and therefore from the evidence of the ballistic expert, it cannot be said that gunshot injury was caused to the deceased only from the rifle recovered from the appellant. Non-recovery of the bullet cannot be said to be fatal to the prosecution case, since benefit of doubt is given to the accused on the aspects like darkness in the place of the occurrence and doubts as to who caused fatal injury. We are not inclined to consider the merits of the contention assailing in the opinion of the ballistic expert. There was a darkness at the time of place of the occurrence, making it difficult for the eyewitness to identify the assailant. The evidence of the eyewitnesses are contradictory to each other as to the firing of the fatal blow. The guilt of the accused has not been proved beyond reasonable doubt, and the benefit has to be given the accused. There are 21. The conviction of the appellant accused 1 under section 302 read with such and such. Under unsaid such and such. Set aside appeal is allowed.
Mr. Hussain, in this judgment, please come to para 13. In the complaint filed by the complainant Sombhai Rupabhai, PW3, it has been stated that the appellant accused 1, Ashok Singh, Jaisin Singh, and the accused number 2, Kalu Singh, fired 3 gunshots from their guns. So therefore, there are 2 persons who are shooting. So therefore, whose bullet had killed this man? Because it is 302 strict evidence is required. So that is why this was discarded.
The conviction was made Ashok Singh and Jayendra Singh in that case. That is why the
Supreme Court says that 2 people, there was 1 gunshot, 1 bullet entry, and that bullet was never recovered. So therefore, it was from whose bullet that is not proved.
That is why accused appellant 1 was.
But here this was recovered.
No, I am trying to say the bullet was recovered. Bullets fired out from the certain gun carbine. That was not issued to me where from the gun the bullet was.
So that has been manipulated. Manipulation is there. in
lord,
the register.
even my lord, assuming the manipulation, my lord, the from the 6 and it is 0, not 8, my lord. That
You
that
have
are
been given the 6. Let us assume it's a 0 or 8.
8, my lord.
Where is that government?
My lord, the gun was issued is the 6th. Signature is mine, my lord. The bullet was not came out from the gun.
Why there is a manipulation or overwriting?
My lord, that is why.
No, because you
the
see,
Evidence.
no, it is that A which has fired.
Right.
That what you call as per the forensic report, it is the A from which it is fired.
Fired.
And that is
The E.
and that test
The A is a 8.
ballistic report is there that if it is fired, the same imprint is there. But in the fired bullet, since it has extraneous marks, it could not be matched.
Could not be less. My lord, taking into my lord,
So
assuming
irrespective of whether there's that 0 or 8, whatever was issued.
Correct.
But this bullet was fired from 8, the same
well, it cannot definitely say it, my lord, the ballistic expert no evidence, my lord, last line, my lord. I do not know if exhibit E, that is bullet, was not fired from exhibit E. So,
No, because he's a scientific expert. Unless it matches, he can't say.
well, that is. So that is why the Supreme Court said the expert opinion of the ballistic expert opinion cannot be, my lord, ignored. My lord, assuming, my lord, it is not mass, that is why the bullet was, it cannot be said that the bullet has came out from the exhibit A, my lord. That is why in the, my lord, in the judgment, my lord, Supreme Court said we are not inclined to consider the merit of the contention of the arising of the ballistic expert. So here, my lord, ballistic
No,
expert,
because in this case, other aspect was considered to give the benefit of doubt.
well, only because of the evidence, only basing of the evidence of PW1, my lord. This conviction, my lord, in the judgment, if your lordship, my lord, my last findings, my lord. My lord, that is para 21 of the judgment, my lord, page 79, last line. PW1 in this case is an eyewitness. My lord, absolutely cannot be eyewitnesses. His statement 161, my lord, he has not seen the firing, my lord. He came down after hearing 2-3 minutes, my lord, hearing the bullet, sound of bullet. He is an eyewitness, widow of the accused, and the fact that was present at the place of occurrence, find corroboration of PW2. PW2 said, I have not seen. PW3 same. 7 also same, my lord. PW9 also say same. Each of them corroboration are one another in static. Then victim had pointed by gesture towards the door of the accused when she was asked by TW1 as who the assailant was. Malad showing fingering, malad pointing finger to, there was a 4 quarters in the ground floor. This part of the, it cannot be said beyond reasonable doubt. This part of the testimony of the said witnesses could not be impeached by the accused. PW9 has stated that he has reached the place of occurrence after 5-7 minutes of the incident. At that time, the accused was not in a position to speak. However, that would not mean that immediately on receiving the gunshot and being fled thereby, when PW1 was holding him, he was not in a position to speak, and therefore, but that being so, they have taken the account note of the evidence of PW1 that twice my husband said that Athwar killed him. That is contradicted by the IO and PW7. Therefore, testimonies of the some of the witnesses that when they had seen the victim was not in a position to speak, does not be the case of the person. These are presumption. 302 has to be the all beyond all reasonable doubts. It may be a matter of second when an injured person moves from a state of being able to speak to a state where there is no longer to able to speak. Then the evidence of the PW herself contradict with the PW of evidence of PW 9 and 11. eyewitnesses account clearly point out to the accused being the only person who had shot at the victim. The medical testimony clearly showed that death of the accused was a result of gunshot. Well, this is a gunshot, it is a, there is no doubt, my lord. It has been shown above the used pellet of the bullet recovered from the place of the weapon was, in all likelihood, fired from the carbine from the house of the quarter of the. Even then, wife of the accused stated the carbine with the body number such and such was recovered from the official quarter of the accused, and there is no explanation from the accused as how did he come in the possession of the said carbine if it was not issued to him as official. But it is in the record. It was issued in the official to him. This further point manipulation of the exhibit 10 having been done in order to screen that. Well, for that matter, the other those who seized the carbine, the official records matter, for their mistake, their fault, am I not responsible? And it is has to be beyond reasonable doubt. Well, there was a darkness, man. In the sketch maps, the light post is the some distance away from the corridor, man. So, Lordship, the sketch map mallet is 115. Man. Now, my left page 95, the scissor
I'll
list.
just show you something. I am not commenting. The incident in that case took place on 23/11/1997.
Right.
Correct. In the center, I have shown you the phase of moon. It was waning crescent, and the illumination is 36%. You've seen that?
My lord, in the middle, my let's say.
Yes.
My lord.
So moon position was that waning crescent, and illumination is 36%.
36%.
It cannot be
But-
pitch dark. It cannot be pitch dark.
It can't be pitch dark. No, but this the citation he has given, there the finding is that it was dark in the night at 9 p.m. I'm just demonstrating that it was not dark. It was not dark. 36% illumination was there. Let's see that that will be interesting. You may.
Interesting, my lord. Yes, yes.
Show it to her, Ms. Jahan.
It was gone into.
Yes, so much depth in my lord.
Now, this only proves that I have no other work.
The waning present illumination is 36%. March 20, November 25, 97. That is why we are here and all.
My lord, that's yeah.
Therefore, be very careful.
Uh,
Yes. So, my lord, base 95, my lord.
95.
My lord. Caesar list, my lord, MR. Hogendra Chandra Roy, my lord. My lord, place of Caesar, my lord, magazine guard, police reserve, Sirang. Date and time of 4th April 2013 at 10 AM.
Yes.
It was produced by my lord Sabed Ali, the evidence, my lord, PW. And the evidence of PW is
Just now.
stated, my lord. Caesar list were prepared probably at the police station. So, my lord, maybe whatever the manipulation, whatever the amendment.
Exhibit 10. Exhibit 10 was by PW 5. Correct.
My lord, my lord. Sabed Ali.
15, 10, 15. But then, John, you'll have to show us something more.
PW5 say Caesar list were prepared probably at the police.
This original original exhibit 10 is not there.
That register pages are only there. Entire register,
Is
One is the cover book.
entire register is there.
no, no.
Okay, only those 2 pages are there.
Those are 2 photocopies.
Right.
And
That brown book is not a register. The lordship has already.
that is exhibit 9. Is a command
Come on.
register. This is that. But here it is written compared with the original. The order of he was examined on 15/10/15. 15/10/15 does not say that what do you call it was proved in original. Just
All photocopy that is.
In the evidence, please read PW5, does it say proved in original?
No, but
No, neither he talks about photo state copy. That's it. Exhibit there.
the register has been brought today. Register has
Just see
been.
this.
Material exhibit 10, one is the photocopy of the relevant page.
There, it's written.
Yes,
Exhibit 10 is the photocopy of the relevant entry. All copied in original.
Which page?
Page 23.
23. 2 lines.
All proved in original, huh?
That is right.
The entire register was brought. Exhibit, material exhibit 10 was the arms and ammunition issue register.
Hmm.
Material exhibit 10.
Yes.
Is the register of the issuance of.
Exhibit 10 is duty slip.
So then it will be required.
Okay.
Then the original has to be called for.
Can be called for and seen during the time of hearing. Material exhibits. The entire register.
Mr. Hussain, we are not inclined to grant bail. But we'll give a short date for hearing of the entire matter. Because if we evaluate, we are not finding it a case for bail.
It is not a case beyond reasonable, the conviction was made on the beyond
So
reasonable.
that may be, you may be correct. Because if
With
the,
any condition more than a year behind the permanent, let this come out from sometime, then hurt the.
no, no,
Consider-
suspension may not be granted.
Even if we consider PW1 not being an eyewitness and other evidence on record. And eyewitness also we have to see it in minute details during hearing because the bullet entered through the back and it made the exit entry to the front. So it shows that the accused, that the deceased was climbing upstairs. This accused had fired him from the back.
No,
The wife was coming downstairs from the third floor. He was going up from the first floor. There's every possibility that she had seen.
no,
But
that,
contradictions, we will go through during the time of hearing.
well, it is,
Complete other evidence, dying declarations, oral dying declarations. 2 and 3 had seen him coming up with the carbine in his hand. Carbine was seized from his place inside the VIP box. Same carbine from where test was carried out. And it was found to be matching. Because there was some impressions, some marks. So there are so many evidence.
Well,
One was missing. 20 bullets, 20 rounds from one was missing. PW 5 and 6, Lordship has already seen. So many evidence on record are there.
well, rest of the PW 2, 3, 4, 2, 3, 5, 7.
It's okay, that may be gone for acquittal, but not for bail at this stage. Bail we are not inclined. We'll fix the matter for hearing in the week commencing 11th of September.
Material exhibit, the lodge calls for because only 2 pages are here.
No, for that, we'll direct you to make a photocopy, get it certified from your armory and send us instead of the original one. Hmm?
Original proof is proved. It is proved in original.
No, but the manipulation will come to know that it is whether the original itself was manipulated or it is the photocopy which has been manipulated. Because if the original was manipulated and you did not take steps to get it rectified, then I think Mr. Hussain may get a benefit out of it.
If original is 6, then or 0. Whatever.
Because the report of the armory will have to be relied upon if there's a dispute with regard to the issuance, then the benefit will go to him.
There will be no doubt there.
Interlocutory application where Mr. A.K. Hussain, counsel for the applicant, and Ms. S. Jahan Ranil, AVP for the state. This interlocutory application has been filed for suspension of sentence during the pendency of the connected appeal. The learned counsel for the applicant has made an endeavor to refer to all the witnesses examined by the prosecution to project that there is no eyewitness to the incident and has brought on and has demonstrated that the PW1 in a statement made before the police under section 161 CRPC had not given a statement that her husband before dying had named the appellant as the assailant. So he has also endeavored to demonstrate that the in the
He has not seen.
carbine issue register within bracket exhibit 10, there is a manipulation with regard to the carbine number issued purportedly to the applicant. Stop. Accordingly, it is submitted that as there was no eyewitness and that the evidence of the PW1 and PW3 were stated that the deceased before dying had named the appellant as applicant as the assailant by pointing out and also pointed out that this quarter was not enough to enough for the court to hold that the circumstantial evidence against the applicant or direct evidence against the applicant of having committed the offense of murder could be proved. Full stop. Next, in support of this submissions that in the absence of expert opinion on ballistics, that the bullet with which the deceased was killed was fired from the carbine issued to the applicant the ballistic opinion by the FSL would not be sufficient to convict the applicant. Reliance is placed on the case of Ashok Sen. Number one, Ashok Sen versus State of Gujarat and others, 2019, 6 SC 535. And to support his contention that in the absence of proof of motive of the crime, the prosecution has not been able to prove that it was the applicant who was the perpetrator of crime. Reliance is placed on the case of Kumar versus State represented by Inspector of Police, 2018, 7 SCC 536, serial number 2,
Para 30,
para 5,
34,
30.
34.
Next one. Our contract, the learned APP has submitted that even if the statement of the PW1 and PW2, PW3 was not admissible so far as, assuming that it was not admissible so far as they claim that the deceased before dying had named the applicant as the person who had shot him. There are other evidence which point towards the guilt of the applicant. Because one missing cartridge from the carbine was not accounted for. Next paragraph. Having noticed the nature of evidence which has come out against the applicant, the court is of the considered opinion that this would not be a fit case to release the applicant on bail at this stage. First of all, at this stage, the court is disinclined to evaluate the evidence to find out as to whether or not the conviction of the appellant was based on sound evidence. So, for an overall review of the matter, and taking note of the decision of the Joint Trial Court, thereby convicting the applicant, the court is disinclined to release the applicant on bail at this stage. Next, accordingly, this prayer for bail stands rejected in appeal. Heard so and so. As the paper book is ready and the LCR is received, let the matter be listed for hearing in the week commencing 11th September 2023.
Let it be 18 September. Week commencing from 18 September.
Week commencing from 18 September 2023. Next para. In the meanwhile, the learned APP shall call for a true copy of the relevant pages of Exhibit 10 from the with whom from the
Registry would have done better.
no, because the original, if original is taken away, this will go back to your armory over which you have control, we don't have.
Sound must have gone
Huh.
to the art trust. Registry can also be from the army concern. Registry can also do it from the 2 copies from the armory.
This from which place?
So it's Kajol, Dhaligarh,
Huh?
Chirang, Dhaligarh.
Police Reserve Chirang. You say, people will make an attempt to communicate with the in charge of Police Reserve Chirang, so as to obtain 2 copy of 2 copy of relevant pages of Exhibit 10. I.e. the carbine issue register containing entries between 6/10/2012 TO2 5/11/2012 contain entries of issue
Yes, sir. 16/12 to 5/11.
6/10/12 to 5/11/12. Next para. The registry shall also issue a requisition to the in charge of Police Reserve Chirang District for transmitting a true copy of the arms of the ammunition of the magazine issue register containing entries of issue between 6/10/2012 and 5/11/2012. Procedural, which shall be duly certified by the in charge of the armory. It is called armory, right? Uh, Armory of the magazine of the.
Police reserve, it is in the police reserve. It is in the police reserve, the
The police reserve Chilani.
Chirangbar. Magazine guard, police reserve.
Magazine
Guard, police reserve.
Magazine,
Guard, police reserve.
That is where I found.
95 base. 95.
no, from the magazine guard. Police reserve Chirang.
Connecting to Dhaligaon PSK, it will be specific, convenient more.
Which was seized on 2/4/2013 in connection with Dhaligaon PS case number 174 of 2012. As per the learned APP shall also send a downloaded copy of this order to the concerned authorities for sending the same list for hearing the week commencing 18 September 2023.
Hello.
Item number 5.
5 is the appeal against.
State appeal.
Yes. We have taken steps to the OC for service of notice upon resolve respondent. That has not come back. That their report is awaited. And earlier, actually, the step was wrongly taken through registered post. We had rectified. It is sent to the OC now, but the report is awaited. This is a POXO matter.
Okay.
We can await for some more time.
As John Leonard, counsel for the applicant has referred to office note dated 7/8/2023, indicating that service report has not been received. Next, accordingly, the registry shall issue a reminder to the officer in charge. Which police station?
This is Morigaon.
Morigaon Police Station. No, it's not Morigaon.
He had taken the notice to Morigaon.
This is Lahore, PS is Lahori Ghat.
But I think the notice was taken through Morigaon PS.
They will never be served.
This is otherwise case was registered Lahori Ghat police station.
Morigaon is the district,
Hmm,
Lahori Ghat.
Lahori
From the
Ghat.
concerned Lahori Ghat Police Station.
Then we'll have to take an again. Or I can tell the OC Morigaon to send it to Lahori Ghat police station.
Yeah, great. Next, meanwhile, the learned
Yes.
counsel for the applicant, who is the additional public prosecutor for the state, shall also pursue the matter for expeditious return of the service report.
Gotcha.
This after 3 weeks. We'll continue at 2. We'll continue at 2 because in 10 minutes matter will not be there.
At 2.
Item 6.
Gotcha. 6 is the LCR is here.
There's an
Paperwork.
office note.
Lordship can direct preparation of the paper book. LCR is here.
Paper is not ready.
Eight. Yeah. Why? How many days? I don't know. Time is running.
The matter query for the appellant is not present. Ms. Jahan and APP is present. As per, it's not dated 7/8/2023, NCR has been received. The paper will be prepared by the registry in the meanwhile, list after 4 weeks. We continue to.
Lordship.
With regard to item number 13, hearing matter, the lordship will be sitting at single bench also. This will take some time, madam. May not be possible to do it.
So be present on the case. As Jahan APP.
After 2 weeks, 3 weeks.
Give it.
Lordship. Of land.
In item number 16, 17, and 18, my lord.
These are debt reference cases
Debt
along
reference.
with the life sentence.
Yes, madam. The learned senior counsel, my lord, he is unable to come to. So can it be taken after 2 weeks?
Independence Day matter also. Independence Day, Independence Day also. Independence also.
Okay, you want after 2 weeks? The Prime Minister, Mr. J. Payan counsel for the appellant. This after 2 weeks.
Number 7.
Please, your lordship, LCI has been received, lordship, kindly fix my hearing.
The paper book is required to be prepared.
A paper book to be prepared.
Both sides are duly represented. It is seen that records have been received. According to the registry shall expeditiously prepare the paper book list after 4 weeks.
Eight days and I've missed, in fact, 2 matters from today's list. I've missed the matter. I didn't file my objection. I had otherwise taken 2 weeks, 3 weeks time. I missed, I don't know. I don't have the paper book or the papers also.
Yeah, Lordship, he is in custody for 1 year. Lordship may kindly peruse the statement of the victim because here the
But still, in this offense, we have to have an objection.
they have Lordship, they were granted time.
Time, yes, I know.
They
I
have
have.
not filed. But
Yes.
only one thing is that Lordship, victim is the appellant is 20 years and victim is 48 years. Even she in her statement said that I do not know who was the person because it was a dark night. She did not wanted to lodge the Azhar. Villagers forcefully lodged the Azhar. It is also in the evidence, her evidence. And he is behind her for 1 year. Lordship.
Make it within a week.
Within a week, I'll take the papers from him today within a week. There's no appeal to delay, I'll return you. I'll file it on Monday.
Next week, any date we will fix.
But this will otherwise also be have to be deferred. The notice has not been served.
Notice not served.
This is the 376. Not
So-
POXO,
Huh?
not POXO, 376.
But here also it's an offense against the women. We have to issue a notice.
For consideration of bail or it is not required. Because,
Technically,
because
by seeing the
399,
notification, not required.
439, it is only specific categories are there where victim is minor. That in 376, it is not required.
By going by the
For regular
notification,
bail
not
also it is
required, but POXO only is required.
Because 439, that
In
notified.
the appeal, right? Both sides are duly represented. The registry shall call for the service report in respect of respondent number 2. Just after a week. Just a list on so and so. And in the interlocutory application, you see the Ms. S. Jahan Lanan, both sides are represented, Ms. S. Jahan Lanan, ABP. Submits that she has missed the matter and pays for some time to file. Pays for time till 14th August.
Noted?
14th August
No, 14
to
hours.
file objection in the matter. Next for list on
17,
17/8,
17.
and in this main matter also write 17/8, list on 17/8.
Outline.
Nine same, LCR is here, paper book is not ready.
Type the paper to be made. Both sides are duly presented. It is noted that the LCR is received. Hence, the registry shall expeditiously prepare a paper book. List after 4 weeks.
Then here I file my objection, it's on record. Deposits are here.
HR has already received your lordship. There's an IA for bail lordship.
Hmm.
The IA for, we have to go for the evidence lordship. So lordship can pass the order for prepared paper books.
Okay. Both sides are represented. Mr. T. Gogoi, counsel for the applicant of the appellant, has submitted that for the paper book is required to be prepared for appreciation of evidence. Consider the connected interlocutory application for bail. Next, accordingly, the registry shall expeditiously prepare the paper book list after 4 weeks.
Outline.
Here also I've missed this matter. I'll file it on Monday. The objection to the IA. I'll file it on Monday.
Same, both sides are.
I'll take the copy. Copy I don't have.
That last order I gave, objection on 14th, same order. here.
17th, matter will come up.
And this one 17, same order here.
Well,
May I please allow-
This one.
We had a miscase is filed for for necessary order. Earlier lordship in the repetition, order was passed, annexure A lordship. Annexure A, case 13.
The matter before the cat is pending.
Lordship.
The
Matter is pending, but lordship, we have approached the honorable court earlier because the honorable court, honorable tribunal was not disposing of the matter. In spite of the lordship, all the hearings are completed, and at the time when this matter is at the hearing stage, lordship, the honorable tribunal had directed to allow the respondent to rejoin in the sector headquarter Romia, from where he was transferred to Almora lordship. In
No, you see,
earlier, he was released from Romia lordship, but
that order is not on a challenge.
lordship, we have filed MA, and in the repetition, we have challenged it, but this honorable court has directed to dispose of the matter on the date that was fixed on 12/6. But on that date, when this matter was listed, the honorable tribunal, without hearing the parties, lordship, adjourned the matter till 29/8
Where is that?
at page 15. No one has sought for the adjournment, lordship. It is not known on what ground the adjournment was granted, because it was for disposal. It was direction was to dispose the OA.
Let me issue direction. Because once the hacker is passed on that, to dispose of the next day, they can't adjourn it. So otherwise we have to look for content. We give advice to the respondent, the cat.
Due to pendency of this OL, some difficulties has been caused because there is a shortage of engineering cadre officers in the SSB. And in the Almora, there is no officer.
Okay.
And at the
And
last
this-
moment, lordship.
Are they will and CGC appearing for the applicant? This interlocutory application has been filed for issuance of appropriate directions. Next para. The learned CGC has submitted that agreed by the order dated 3/1/2023, passed by the learned Central Administrative Tribunal, Guwahati bench in MA 48 of 2022, the connected WBC 3004 of 2023 was filed. This MA 48 of 2022 in OA 109 of 2022, this writ petition, the connected writ petition being WBC 3004 of 2023 was filed. Full stop. Accordingly, this court on a consideration that OA 109 of 2022 is in the hearing stage, and the next date was fixed on 12/6/2023. Disposed of the writ petition by order dated 29/5/2023 by requesting the learned Central Administrative Tribunal, Guwahati bench to finally hear and dispose of OA number 109 of 2022 on the date fixed for hearing, i.e. 12/6/2023. Next paragraph. The learned CEC has submitted that on 12/6/2023, without assigning any reason whatsoever, the Central Administrative Tribunal, Guwahati bench, Guwahati, adjourned the matter to 29/8/2023, and thereby violating the order dated 29/5/2023, passed in the connected WBC 2023 of 2023. Next paragraph. The next paragraph, the learned CEC has referred to statement within paragraph 5 of this interlocutory application to project that the certified copy of the order dated 29/5/2023 was submitted before the registry of the learned Central Administrative Tribunal, Guwahati bench, ahead of the date of hearing. But the same was not considered. Full stop. Next paragraph. As the learned CGC has submitted that the certified copy of order dated 29/5/2023 was submitted before the learned Central Administrative Tribunal, Guwahati bench, Guwahati. The adjournment of OA (109) of 2022 by order dated 12/6/2023 by a mere order to the following effect, inverted comma start, adjourned to 29/8/2023. Expressly appears to be contemptuous. So if the learned Central Administrative Tribunal, Guwahati Bench, Guwahati had compelling reasons to adjourn the matter, this court would appreciated some reason assigned to adjourn the matter. Full stop. As no reason has been assigned to adjourn the matter on 29/8/2023, despite the order of this court dated 29/5/2023 in the connected WBC 3004 of 2023 is not at all appreciated, or rather, it appears to be contemptuous. It is contemptuous or contumacious? Contemptuous is also contemptuous. Next one. Be that as it may. In terms of order dated 29/5/2023, passed in WBC 3004 of 2023, we once again request the Central Administrative Tribunal, Guwahati Bench, Guwahati, to hear and dispose of OA number 109 of 2022 on 29/8/2023, the date fixed by order dated 12/6/2023. Next paragraph. At this stage, the learner CEC has submitted that the respondent herein was transferred to
Almora, Lordship.
Almora,
You can
where there is a urgent requirement of personnel, and that and therefore the administration of the Sashastra Seema Bal is adversely affected with lack of personnel in Almora. To stop. We hope and trust that the learned Central Administrative Tribunal shall take into consideration this said submission. And hear the matter, hear the OA 109 of 2022 on 29/8/2023, the date fixed. Next paragraph. The court is inclined to direct that that the office of the Central Administrative Tribunal, Guwahati Bench, Guwahati, on receipt of a certified copy of this order, shall provide an acknowledgement of receipt to the learned CGC. With the aforesaid observation, this interlocutory application stands closed.
Lordship, under if the further adjourned method, then it may be considered for transfer to other bench, Lordship, because undue delay has been caused.
Do we have that jurisdiction, or you'll have to move the principal bench at Delhi? You think power of transfer is available with us?
Lordship, it can be transferred by the principal. Yes. Lordship.
You can file a contempt or
Otherwise, but power to transfer would be before with the principal bench.
Lots,
You think over, that is what we think,
lots,
but you take a call.
lots. All right, that's it.
14 and 15 for hearing.
No, I am appearing item number 15, my. Here, what has happened, my lord, though an order of this honorable court is there fixing the case for hearing, my lord. On the other day, that is on 1/8, my lord. The analogous, my lord, appeal, my lord. IA hearing was disposed of by another coordinate bench of this court, my lord. So I mentioned this matter, my lord. My IA also is pending regarding item number 15, my lord. So may I pray, my lord, to will take up that IA, my lord.
No, when we are hearing the main matter, why should we spend our time in IA?
Mine. But the other day, my lord, it was taken up and it was disposed of.
No, we don't know, but here we are at the hearing stage.
Mine,
So when we are hearing the entire matter, why we need to spend our time on IA?
mine. I appreciate.
Huh.
Mine. Here, what was happened, my lord? There are 129 witnesses, my lord. And my lord, with all respect, I am in item number 15, my lord. There are 10 appellants, my lord, before your lordships, my lord.
This is that
Yes.
matter of Karbi Anglong where for 10 rupees, the driver, auto driver had killed a student of law student, long back, Chankar. Lordship will remember.
Difu incident.
Difu.
Very
I'm not even-
unfortunate incident.
That law student was coming by an auto. They had an altercation because of 10 rupees. Thereafter, he was killed by a mob. Here, the father is the main witness.
Okay, I am not recollecting the incident, but yes,
Mine.
Lordship will remember that was a big incident at what point. That was in the year 2000, KTR,
2013, mine.
2013.
maybe I'll recollect when I.
Lordship is sure to
Okay,
recall. Here, although there are 129 witnesses, but the father and other police personnel are the main witnesses who have seen and identified the accused persons. This will not be over, I think, and Lordship is not there next week. This will not be over today if your Lordship continues with the hearing. And I've seen the roster. Lordship is not there.
Is it? No, then I think.
But
we should
Lordship
not-
has kept a parted matter on Monday. For
No,
dictation.
but then it will be, what you call, that will be, since it's a,
Huh.
if it's a partner matter, then
Reconstituted.
naturally will be reconstituted only
Constituted.
for one matter.
Perhaps. Monday, there is no division bench probably.
I don't know. Nowadays I keep a track of only one.
Yes, Lordship will not have the time.
No. Because in my courtroom, I get only, I take only one cause list. I
Yes.
confine myself to this cause list only.
Yes.
I don't
This is
get the printout of the
Ah,
entire cause list.
not required. Not required.
No, I don't know. I am self-contained man. Self-centered.
We are advocates, see each and every list. So,
I am self-centered, so. Nothing beyond me.
That being so, my lord, may I pray for 2 weeks' time, my lord, because I will be out of station, my
Okay. We commencing
lord, from Monday, my lord.
21st.
20.
We commencing from
Mine,
21st. Okay. All sides are duly represented. Just all. It appears from the volume of evidence which is available in this appeal that it would consume some time and could not, will not be concluded today. According to the matter sense
The court is inclined to defer the matter. Next para as paid for by learned counsel for the appellant lists the matter in the week commencing 21/8/2023.
21.
Can it be, my lord, in the month of September?
You give me a date, we'll fix it on then.
My lord.
Give us a date. You have a calendar in front of you.
September, there are holidays, so 11 September.
11 September.
কি হবে না?
11.
Oh, week commencing from 11.
We commencing. Okay.
So 11, informant will not be there.
Okay,
12th,
we'll fix it on 12 then.
12th.
My
12/9/2023.
lord. Okay. God bless.
Tuesday.
It's a Tuesday.
My lord.
I have my time for you can go. Do in seeing the two.
Trial court is November.
Then
Then we have it on
14.
14th then,
My lord. My lord.
14/9.
God bless, my lord.
This is.
Manasda. Yes, I second. Yes, I second.
Oh, what it?
We were just discussing within ourselves
My lord.
that so far as prime accused is concerned, there are 5 witnesses which are material out of 129.
5, 6,
5 or 6.
6.
3 are police people who got the information, they came there and they saw assault. Then their father is there. And there are 2 other witnesses who have independently they have said about it. So volume would not be a deterrent. factor.
Yes, yes. In a way, it's a small matter. Other witnesses have simply said there is a fight we have seen and nothing more.
Nothing more.
So those witnesses can be discarded. Only
My
these.
lord, 302 will not sustain my lord.
No, I don't know because of this. You see, because of this much of volume, we did not go through it.
No,
on the
yes,
page.
yes.
Because we also don't know that when we even if we read it,
My lord,
whether the matter would be taken up and held, that we don't know. So therefore, not the entire but snippets of it.
my lord,
Yes,
my lord,
yes. Yes.
So we were discussing what
Ah.
my brother has read and
my
what
lord.
I have seen. We just discussing, taking 2 minutes time to understand.
And what I meant by saying is Lordship is here in Guwahati, but this bench is not there. So
No, that is
I
okay.
said Lordship is not there. Lordship will be here.
No, tomorrow nobody knows.
It's not.
Tomorrow
That is
nobody
correct.
knows.
My
Tomorrow
lord.
never comes.
This is a fact, really.
We are not seen tomorrow.
37 documents are there. Those are also those 37 number
It's
of
okay. We're
documents.
just trying to think that with the time we have, whether we can still
Ah.
coax you to start.
Lordship can also start now, I think.
No. Next week, if I'm not there, then we won't come.
Ah.
Knowing Mr. Sarni, I will not leave me so easily.
No, my lord. I have no choice at all, my lord. Anywhere, my lord. Any place.
By the division bench of this court, by judgment and order dated 5/8/2023, passed in WA 133 of 2023. Next paragraph. It may be pertinent to mention that in WA 133 of 2023, the appellant no, sorry, so the respondent therein was the Gaon Panchayat secretary, had approached this court by filing a writ petition
praying for setting aside and quashing of the order dated 23/8/2018, issued by the Secretary to the Government of Assam, Panchayat and Rural Development Department, by which the state authorities had granted ex post facto approval for creation of 1272 numbers of post of Gram Panchayat Secretary with effect from 30/5/2023 to 2003 TO2 3/2/2016. By further providing that such creation of post shall not be treated for the purpose of Gram Panchayat secretaries to receive pension and other retirement benefits. Full stop. The said part of the order dated 23/8/2018 was under challenge. Full stop. In the present set of writ petitions, the petitioners are also claiming that as the Gram Panchayat secretaries were appointed between the period 35/2003 TO2 3/2/2016, right? Here also same dates. And that by operation of what is that Provincialization Act? What is the name? Assam? 1990? 1999, on and from, what is it, 110? With effect from 1/10/1991, the services of the Gram Panchayat secretaries were provincialized. Accordingly, it is claimed that the Gram Panchayat secretaries, having been appointed between 35/2003 TO2 3/2/2016, have acquired the status of a provincialized employee with effect from the date of their respective joining, they could not have been excluded for the pension and other pensionary benefits under the Assam Services within bracket pension bracket close rules 1969. Full stop. Next part. It is found that the issues raised in this writ petition are squarely covered by the decision of this court in WA 133 of 2023. And therefore, the issues raised in this writ petition do not warrant any fresh determination. Because the division bench of this court, by the order referred above, had not accepted that the petitioners, that the Gram Panchayat secretaries would be covered by the new defined pension scheme, which was made applicable to all new entrants joining the government service on regular basis against vacant sanction post on or after 1/2/2005. Full stop. The operative part of the said order dated 5/8/2023 in WA 133 of 2023 is quoted below. Para 7 is conclusion. Second last paragraph. Next paragraph. As first of therefore, as the offending portion of the order dated 28/3/2018 issued by the Secretary to the Government of Assam PNRD Department whereby it was directed that inverted comma start the ex post facto creation of posts shall not be treated for the purpose of enabling the person concerned to receive pension and other retirement benefits, comma, inverted comma closed, being struck down as perverse and not legally sustainable. Comma, the present set of repetitions deserve to be allowed. This 4397 writ petition order you have.
Yes, sir. Yes.
Next one. This court had upheld the judgment of the coordinate bench of this court in WPC 4397 of 2022. No. So the observation of this court in para 10 of WPC 4397 of 2022 is quoted below. No, make it 10 to 12. 10 to 13. Next paragraph. Accordingly, as the order of the coordinate bench of this court in WPC 4397 of 2022 has been affirmed by the division bench of this court in WA 133 of 2023. These petitions are disposed of in by directing the respondent authorities to pass appropriate orders on the entitlement of the Gram Panchayat secretaries who have filed WPC except for number 1. Other matters. So Petitioners in so and so for pension by taking note of the law laid down by the by this court in WA 145 of 2009, WPC 4397 of 2022, and WA 133 of 2023. Next para. The said benefit shall also be extended to the members of the all Assam Gaon Panchayat Secretary Association and another from our WPC 4506 of 2018. The next para it is provided that the petitioners, while submitting a certified copy of this order before the competent authorities, shall also produce a copy of their list of their members. The petitioners in WBC 4506 of 2018 shall produce a true copy of their members list to the authorities. The petition is allowed to the extent as indicated above. Parties are left to bear their own cost. They'll do it. Let them have their time.
No, because we have practically, many of them have retired already.
Because
Some have left also.
because these are they're nobody has prescribed that.
No, it's prescribed here, my lord, in the writ petition order, it's.
Oh, here I have mentioned para 13 is there. So 13 I have quoted. I have said that in terms of this and so.
And one more thing, if possible, my lord, the writ petition says that it will be reckoned by reckoning our services from the date of initial appointment. My lord, in the penultimate paragraph, my lord has said, therein, my lord, by reckoning our services from the date of our initial appointment.
Acha. But past as well, the entitled of the petitioner for pension it also. By taking
Initial
note
appointment in 93.
by taking note of the respective date of initial appointment
Initial appointment, my lord.
and by
the-
taking law laid down by the dispensary. It will khali add appropriate. Next para. The appropriate orders, the consequential orders be passed by the respondent authorities within a period of 2 months from the date of receipt of certified copy of this order.
Initial appointment, my lord, is in the year 1994. Or they will now confuse it with 2000. Initial appointment is of 93-94.
No, I think that that you will not get the benefit. It is from the date of your provincialization. That from that day.
We stood provincial. Fine, then ambiguity.
No. You see, no. If that is so, we'll have to settle it. You see, the period when you are appointed, not on the basis of the
Yeah,
rules, because then you were appointed not by the competent authority.
Yeah, right. Panchayat Raj Institution.
So that benefit you can't get.
No, here the 4397. Accordingly, it is provided in paragraphs of the provision society, including the provisions. A pension would be available on or after 1/10/91 on the basis of the length of service reckoned from the dates of their initial appointment. Para 10 last line.
But that is not the correct law.
Because why if they, so my lord, if that is under the provincialization act be coming, then my lord, from the date of our initial appointment till 2000, that period. Or my lord, we'll leave it in this one, let us see how they write. Yeah.
You see, because because that can't happen. The date of provincialization, from that day you get the benefit. Because otherwise it will open a Pandora's box. You see, there are thousands of teachers who are before this court for the provincial service, and then therefore, if we lay down a law saying that it will from the date of initial appointment, that would create a very big problem.
My lord, we'll keep it open for a second. Can come back. My lord will not touch that. Let it be like this. Much obliged.
No, but if I clarify, I'll be going against it because I have my own reasons. You see, this is not only one case which is before us. It will affect the thousands of people, and there will be ex facto, what you call, even post-retirement people coming here saying that initial appointment has to go back, relate back to the date of initial appointment.
My lord, this much only we get it, we get pensions.
Ah.
We get it. Much obliged.
Whether you have experience of that, I don't know.
But the entire exercise of doing this teachers cases, we have seen in the old building earlier. You know the amount of effort which was put in those cases. I think those were, you were not there at that time. He will tell you.
Much of it.
He'll tell you the day-to-day monitoring. The records were here. Examination of records were done in the courtroom.
Much of it.
He'll tell you.
Police also, police cases also.
You go to his place with all your colleagues. He'll give you some tea snacks and then tell you the story.
So and so was. Give me all that.
One, 2, 4 for admission.
Mr. Nair. Just in a, just to, what do you call, to make myself clear. I had taken a lot of time and then I was against you.
In this case, no. Providential people.
I had my own reasons to say that because the theory which I developed was that for two different purposes,
Lordship.
the government can come up with a scheme because it is ultimately the government who will be managing their own finances. So therefore, when they are extending a benefit, they may curtail that benefit because that can be permissible.
But my subject to what my lord would say, my reply to that was, in the given case, my lord, the date is 1/2/2005.
It's
And
okay.
and the law is, my lord, that if you are there before 1/2/2005, then the new pension scheme cannot be. They cannot forcefully apply it. That would have been my reply to that.
No, it's okay. But since
Fine,
the
no.
matter is over and we are,
I'm thankful, my lord said that. Much obliged, Your Worship.
because I was in favor of the revenue, in favor of the state because of the.
It would have been a plausible view, my lord. It would have been a view. It would have been a view. My lord takes that it's a policy decision and then they have curtailed it. Fine, my lord. It could have been. And thankfully, my lord. I'm through.
You should be thankful for the delay. You should be thankful for the delay.
No, I should be thankful to Mr. Islam. It's he who has done it. I really appreciate that. He took the pain, my lord.
You're good.
Much obliged. Your Worship.
Yes.
But I answered both the queries, my lord, regarding firstly the applicability of the dealer regulations, my lord, and my lord, that are items mentioned in the schedule.
Just a moment. Unless I look at my notes, I will not remember anything. You were last referring to page 51, which is TP.
My lord.
You were showing me the TPs last.
Last, what had happened, my lord, my learned senior, my lord, respected senior, produced a regulation, my lord, showing that regulation was issued under section 26(3) of the Act. So accordingly, my lord, these cases should be covered under those regulations, which I, my lord, respectfully beg to defer, my lord. For that, my lord, I would like to take your lordship to the minor mineral concession rules 2013. Rule 21E and Rule 3, my lord.
Just wait for 1 minute.
Right.
Let me change over. Just take a seat. From criminal side to service better and then again to minor minerals.
1E, my lord.
Assam.
एक किताब को ले लो। The new book has come, my lord, Mines and Mineral Act, and it is all.
Yes, yes.
It is all comprehensive.
No, in fact, I requisitioned this book.
My lord.
The High Court informed us that we have too many copies. 75 copies we have. We are in the process of procuring, but it has not reached me. Because Mr. Costa Goge, he gave me, he presented me with his book. So
Right.
I was quite happy with it, and therefore I recommended that they should be purchased.
My lord.
Yes.
Rule 2, 1E, competent authority has been defined, my lord. Rule 2, 1E says, my lord, it's a definition part, my lord.
Yes.
Competent authority means the Director of Geology and Mining, Assam, in respect of minor minerals as listed in Schedule X, or the Principal Chief Conservator of Forest and Head of Forest Force Assam in respect of minor minerals as listed in Schedule Y, or any other authority specified by any government notification for exercise of such powers or carrying out of such functions as specified in these rules. Now, my lord, if we turn to Rule 3, my lord.
So you're saying that Schedule Y is by
Geology. X is by geology.
X is by geology, Y is for
Y is for forest. Rule 3, my lord, will kindly see.
yes, Rule 3.
Rule 3, power to grant mining lease. Power to grant mining lease or mining contract or any other concession or license or transit pass or permit, etc. Immediately after the definition clause, ma'am.
A mining lease or a mining
Yes,
contract.
my lord. A mining lease or a mining contract or permit or any other concession or license, my lord will kindly take note of, or transit pass or permit or license or control or regulation of mining or other actions under these rules shall be granted, taken by director in respect of minor mineral for industrial and specific uses as specified in Schedule X, the Principal Chief Conservator of Forest and Head of Forest Force Assam, or any officer to be for Schedule Y, my lord. So in respect of Schedule I items, my lord, PCCF and HOF is the authority who can issue mining lease, mining contract, mining permit, transit pass, licenses, or regulation of mining and other actions under these rules. So, my lord, if we now come to the regulation, my lord, rules, my lord, that my learned senior on the last occasion placed, my lord, that is called Assam Minerals Regulation and Dealers Rule 2000.
Yes.
Here, my lord will kindly see Rule 2B at the bottom of the page. Competent authority means any gazetted officer not below the rank of Deputy Director of Geology, Deputy Director of Directorate of Geology and Mining Assam as authorized by the government in the Mines and Minerals Department. Next, my lord. C. Competent officers means a gazetted officer authorized by the Deputy Commissioner or any district or Director of Geology and Mining Assam. Now, my lord will kindly come to clause Z, my lord, 2Z. Department means Mines and Minerals Department, Government of Assam. Then 2K, my lord. 2K.
Just a moment.
My lord. Here, unlike the concession rules, my lord, wherein schedule X and Y are prescribed for indicating the minerals which are under the purview of these both these departments, my lord. 2K, my lord, may kindly see, my lord. 2K
Yes.
mineral means minerals of all types mentioned in the first and second schedule of mines and mineral within bracket Development and Regulation Act 1957. Except the atomic mineral listed in Part B of first schedule of Mines and Mineral Development Regulation Act 1959. So here, my lord, mineral means first and second schedule minerals of the MMDR Act, my lord. So now, if we, my lord, take the MMDR Act for a moment, my lord.
Mines and minerals.
Mines.
Yes.
If my lord is holding the BR Act, my lord, it should be page 34G, my lord. 34G. That's the first schedule. My one is of 2017, my lord.
That is rule.
Not rule, my lord. The schedule appended to the act.
A and B. Part A,
First-
part B.
Part A, Part B. So first schedule is first schedule, my lord, specified minerals. Part A, hydrocarbons, energy minerals. It, my lord, will kindly see the items: coal and ignite, barley and other so and so, lithium, mineral. This has nothing to do with the minor minerals, my lord. Then this part B is excluded, my lord. Part C, if we come, my lord. Metallic and non-metallic minerals. These are some other major minerals, my lords. And see, second schedule, if we come, my lord. Rates of royalty in respect of so and so. So first and second schedule are the minerals mentioned in this rule of 2020. It has no relation whatsoever with the schedule Y, my lord. Again, my lord, if we come to the rule of 2020, my lord. Rule 3, my lord.
You are saying it does not cover any item of minor minerals.
Yeah, not only minor minerals, it doesn't cover any items in at least Y schedule, my lord. That schedule main for forest department, my lord.
And that instructions you have got from your authorities?
That from the record, sorry, the act, my lord, I can satisfy, my lord, that that will include all stones, my lord. Then I'm coming to that. Before that, my lord, in that rule of 2020, regulation and dealers rule, 2020, section 3, my lord. Section 3 says, all mineral dealers shall register themselves as dealers under the Director of Geology and Mining, Government of Assam. Everywhere it is Director of Geology, my lord. Section 4 also says, any person who is desirous of being registered as dealer or required to be registered as dealer or requires renewal of registration shall apply in form to the Directors of Geology and Mining. Everything, my lord, pertains to Directors of Geology and Mining. So, my lord, if we now come back to section 23C, section 23, section 15, my lord, empowers the state government to make the concession rules of 2013. That my lord has already seen, my lord. If we come to MMDR Act section 23C, my lord, it speaks of, my lord, just for my satisfaction, if I may take your lordship to that section 23C, my lord. It says, my lord, power of the state government to make rules for preventing illegal mining, transportation, and storage of minerals. The state government may by notification in the official gazette make rules for preventing illegal mining, transportation and storage of minerals and for purposes connected therewith. If I can place, my lord, this 23C G, my lord. State government is empowered to frame rules pertaining to all illegal mining, transportation, storage, which will also include, my lord, G. G, my lord. Any other matter which is required to be or may be prescribed for the purpose of prevention of illegal mining, transportation and storage of minerals. So in respect of, my lord, Mines and Minerals Department, Schedule X item, my lord, they have come up with this rule up to 2020, notified in 21. But in respect of Forest Department, that rule is yet to be framed. That is why I am relying on a notification of 2003 by which, my lord, the regulation from stone crusher units were framed. 2003 regulations. Under that regulations, my lord, the stone crusher units are to get themselves registered, which the petitioners have not done. It is in operation for last 20 years. So in the absence of rule, our power to prevent illegal mining, transportation of storage is, my lord, we are doing it through the notification of 2003. So in the absence of rule, in the absence of statutory rule, my lord, we are being guided by executive instruction, which is quite permissible, my lord. If we have the power to frame a rule, my lord, we have also the power to frame executive instructions till the rules are framed. So after coming into force of 2013 concession rules, my lord, that notification of 2003 crusher unit regulation gets, my lord, saved. The concession rules of 2013 takes care of most of the things, but regarding stone crusher unit, my lord, it is silent. That's why we are relying on that 2003 regulations. Last day, my lord, from my written argument, my lord, I had already placed the judgment of Sakiri Basu, wherein, my lord, doctrine of implied power. If we have the power to prevent illegal mining, transportation, and storage, then it is ingrained in us, my lord. It is impliedly with us that we, by way of executive instruction, we can control it, my lord, till the rules are framed. Now, my lord, if we go to the schedule of the rule, my lord, schedule X and Y. Schedule X is meant for industrial purpose by Geology Department. Schedule Y is for non-industrial purpose by Forest Department. If I may take your lordship to schedule Y for a moment, at the end of the book.
Should you have this rules?
Rules, 2013 rules. Because in respect of stone at serial number 12, my lord, we noticed on the last occasion that it was to be used for household utensils. That cannot be the only use of a stone, my lord. So I would like to take your lordship to the schedule again, my lord.
Yes.
Serial number 4, my lord, may kindly have a look.
Yes.
It's bolder, my lord. When used in construction of roads and buildings, other than mines in large scale for export and construction of dams, dikes, and bridges, etc. For boulders to be used in construction of roads and buildings. Then, my lord, will kindly come to serial number 5, Single. It is a, my lord, flagstone, my lord, sedimentary rock. Then serial number 5, my lord, 7, Muram. It's a laterite rock, my lord. Then road metal, serial number 9, basically broken stone used in road making. Then serial number 10 is stone. So all these, my lord, come under the definition of rock or stone, my lord. So though we are using the word stone crusher unit or stone, but in the mining areas, my lord, they basically obtain boulders, they break it into pieces. And there are 2 Supreme Court judgments on that. And I would like to take your lordship to paragraph 60. That it's there, my lord. If I forgot. Page 53, that Kumau stone crusher judgment starts, my lord. I would like to take your lordship to page 88, paragraph number 60.
Para
60, my lord. And 63. May I read?
AC দিয়ে দিবো। নাকি? Suffocation হয়েছিল। This time after I had viral fever, this irritating cough is not going. It's a dry cough, but just not going.
This courtrooms, my lord, sitting for the entire day, completely covered, no waterproof, airproof. Unlike the earlier building, my lord, it was so hairy.
I don't know, but this time that weakness is not going.
My lord. Paragraph 60, my lord. Page 88.
Yes.
Paragraph 60. We first take the case of the stone boulders, which are cast into stone grids, stone chips, and stone dust, etc. Stone boulders are obtained from riverbed, stone rocks, and stone mines. After crushing of the stone boulders, stone grids, stone chips, and stone dust are obtained, which doesn't transform into any new commodity, except that the stone in smaller pieces and shapes are obtained. The Allahabad High Court, in its judgment in Kumau Stone Works, decided on 27/4/2005, has given a detailed reasoning for not accepting stone grids, stone chips, and stone dust as a new commodity. It had held that the character of forest produce is not lost by crushing of stone. The High Court of Uttarakhand has taken a contrary view in its judgment dated 1/7/2004 in Kumau Stone Crusher, as noted above. Paragraph 63, my lord. In CST versus Lal Kumar Stone Crusher Private Limited, the court was considering liability of trade tax on stone chips, gittis, and stone ballast. The question raised before the court was as to whether the stone gittis and chips and dust continue to be stone gittis, chips, and dust, or after crushing them, they get converted into a new commercial product, so as to attract the tax on their sale. The case of dealer was that at the time of purchase of goods, sale tax has been paid. Hence, goods emerging out of same are not liable to be taxed again. This court held that the word stone is wide enough to accept various form of gittis, gits, kankars, and ballast. Hence, no tax was levied on the stone strips, gittis, and dust. Then, my lord, that judgment, Lal Kuar Kasar, which was referred to, my lord, page 177 of written argument, my lord. Paragraph 3, my lord. Para 3, my lord. Page 178.
Yes.
The question raised before us is whether gitti, stone chips, and dust continue to be stone or on the crushing stone boulders into gitti, or on crushing stone boulders into gitti, stone chips, and thus different commercial goods emerge so as to attract the tax on their sale. Now, my lord, coming to paragraph 5, my lord, this was the issue. The view taken by the tribunal as affirmed by the High Court, page 179, my lord, affirmed by the High Court, is that the goods continue to be stone and they are not commercially different goods to be identified differently for the purpose of sale tax. The decision relied on by the minority view in the case in the tribunal in Reliable Rocks Builders and Suppliers versus State of Karnataka turned on the concept of consumption of goods for the purpose of bringing into existence new goods. In that case, the court was not concerned with an entry of the necessary with which we are concerned in the present case, where the dealer had brought into existence new commercial goods by consuming the boulders to bring out small pieces of stone. It was held that such activity attracted purchase tax. In the present case, however, stone as such and gitti and articles of stones are all of similar nature, though by size they may be different, even if gitti, kankar, stone, ballast, etc. may all be looked upon as separate in commercial character from the stone boulders offered for sale in the market. Yet, it cannot be presumed that entry 40 of the notification is intended to describe the same as not stone as at all. In fact, all the term stone is wide enough to include the various forms such as gitti, kankar, stone, ballast. In that view of the matter, we think that the view taken by the majority of the tribunal and the affirmed by the High Court stands to reason. We are therefore not inclined to interfere with the same. So, my lord, this siddle, why all these boulders, in fact, will include everything, my lord. That stone part. Stone has been separately meant for household utensils, it's a different thing, but basically boulders, then singly, road metal, these are all stones, my lord. Now, my lord, so, my lord, my submission would be, my lord, stone is a forest produce. As per section 2(4) of the Forest Act in 1927, which is perimeter to 3(4) of the Assam Forest Regulations, my lord. And it has now been already decided by Honorable Apex Court in these two judgments that stone is a forest produce. There cannot be any dispute at this point, my lord, that whether stone is a forest produce or not. So, my lord, that transit fee charge, my lord, as per section 41 of Assam Forest Act 1927, there is a perimeter rule in 41 in our 1981 regulation, my lord. Is my lord basically gives us competence, my lord, both legislative and executive, to control stone crusher units. If we don't have the control over stone crusher, for example, my lord, several stone crusher units inside, my lord, eco-sensitive zones of national park were directed to be closed. If we don't control, my lord, anybody will and everybody will come and set up a stone crusher machine, and they might procure it legally, they might not procure it legally, my lord. It's not only about revenue concern of the state, it's about the economy, environmental hazard that they might create, my lord. So saying that we don't have any control over stone crusher unit, my lord, may not be appropriate, my lord. My lord, at one point of time, my lord, state will definitely make rules for these stone crusher units. But at presently, my lord, the regulation of 2003, my lord, holds the field. And my lord, there are two judgments. Page 146 of my written argument. It is, my lord, Accountant General versus SK Dubey, 2012 for SCC 578. Paragraph 13 of the judgment. The manner in which, my lord, in the boldness in which the petitioners have approached this honorable court, but I would like to remind that, my lord, there is no fundamental right in trade in minerals, my lord. Page 180, madam. I'm sorry, madam. Page 180. That Hinstone case, madam. Paragraph 13, madam. At best, my lord, they can claim violation of some statutory right, which they themselves say, my lord, there is no law, there cannot be any law to regulate stone crusher units, my lord. Paragraph 13 of that judgment, my lord, State of Tamil Nadu versus Hinstone, page 194.
Paragraph
13, my lord, 13. Page 194 of my written argument. In this case, my lord, some renewal licenses were kept pending. And in the meantime, my lord, rule came to be changed. They said that since we submitted our renewal applications prior to the amendment of the rules, my lord, we should be guided by the earlier rules. In that context, my lord, the Honorable Apex Court at paragraph 13 has held. I would like to read, my lord. Another submission of the Learned Counsel in connection with the consideration of applications for renewal was that application made 60 days or more before the date of GO number so-and-so should be dealt with as if Rule HC had not come into force. It was also contended that even applications for grant of lease made long before the date of GO MS number so-and-so should be dealt with as if Rule HC had not come into force. The submission was that it was not open to the government to keep applications for grant of lease and application for renewal pending for a long time, and then to reject them on the basis of Rule HC, notwithstanding the fact that the applications had been made long prior to the date on which Rule HC came into force. While it is true that such applications should be dealt with within a reasonable time, it cannot on that account be said that the right to have the application disposed of in a reasonable time clothes an applicant for a lease with a right to have the application disposed of on the basis of the rules in force at the time of the making of the application. No one has a vested right to grant or renewal of a lease, and none can claim a vested right to have an application for the grant or renewal of a lease dealt with in a particular manner by applying the particular provisions. In the absence of any vested right in anyone, an application for a lease has necessarily to be dealt with according to the rules in force on the date of application, disposal of the application, despite the fact that there is a long delay since making of the application. We are therefore unable to accept the submissions of the learned counsel that the application so and so should have been dealt with prior to HC, my lord. Now, my lord, next judgment 196, my lord. It is Monet Ispat and Energy Limited versus Union of India. 196. Paragraph is 133. At page 275 of my written argument.
Para
133, 133. At page 275 of the written argument.
yes.
The heading says, my lord, no fundamental right in mining.
Hmm.
The applicants have applied for mining lease in a land belonging to the government of Jharkhand, erstwhile Bihar, and it is for ore, iron ore, which is a mineral included in Schedule 1 to the 1957 Act, in respect of which no mining lease can be granted without the prior approval of the central government. It goes without saying that a person can claim any right in any, no person can claim any right in any land belonging to the government or in any mines in any land belonging to the government except under 1957 Act and 1960 rules. No person has any fundamental right to claim that he should be granted mining lease or prospecting license or permitted reconnaissance operation in any land belonging to the government. It is apt to quote the following statement of O. Chinnappa Reddy, judge in Hindstone, that the earlier judgment I relied upon, my lord. Paragraph 6 of that judgment, my lord. A public interest which induced Parliament to make the declaration contained in Section 2, my lord, in terms of 7 serial declaration was made in 1957 Act. The public interest which induced the Parliament to make the declaration contained in Section 2 has necessarily to be the paramount consideration in all matters concerning regulations of mines and the development of minerals. He went on to say, the statute with which we are concerned, the Mines and Mineral Development and Regulation Act, is aimed at the conservation and the prudent and discriminating exploitations of minerals. Surely in case of scarce mineral, to permit exploitation by the state or its agency and to prohibit exploitation by private agencies is the most effective method of conservation and prudent exploitation. If we want to conserve for the future, you must prohibit in the present. So anybody coming to the before a lordship and saying that we will crush stone and we are not accountable to indicate from where we have procured and to which place we are sending it, my lord, that they cannot take that path, my lord, saying that there is no regulations frame. There is a regulation that may not be statutory, my lord. That is saved by our section 23C of the MMDR Act, my lord. Or else, my lord, they will create havoc. In fact, some of them are creating havoc. All this mineral belongs to the state, to the society, not to a private miner or to a stone crusher unit, my lord. on that point, my lord, that in the absence of any regulation as of today regarding stone crusher unit, they cannot take that plea and commit illegality in transportation and storage because they also store minor minerals, my lord. But I would like to rely upon another judgment, my lord. Page 146 of my written argument, my lord. My lord, the judgment is Accountant General State of Madhya Pradesh versus S.K. Dubey and another. I'd like to take your lordship to paragraph 46 of that judgment.
Paragraph 46.
My lord. Page 164 of the written argument.
Yes.
It follows from the above discussion that the state government has power. It follows from the above discussion that the state government has power to issue executive order or administrative instructions with regard to subjects provided in section 16(2) and of the 1986 Act. Where the state rules are silent on any such subject, there is nothing in section 32 or 31, section 31 of 1986 Act that abridges the power of the state government to issue executive order and administrative instructions with regard to pensionable service of the president and members of the state commission. Although the state rules have been framed, but such rules are silent on the aspect of the pensionable service. In other words, in the absence of any provision in the state rules relating to the pensionable service of the president and members of the state commission, there is no bar for the state government in issuing executive order or administrative instructions regarding pensionable service of the president of the state commission. My lord is well aware, my lord, just for my satisfaction, say Article 162 for a moment. I will not go into it, no, just the reading.
In the name of the governor.
Coextensive executive and legislative power, my lord. 162, my lord. Executive, extent of executive power. Subject to the provisions of this constitution, the executive power of a state shall extend to the matters with respect to which the legislature of the state has the power to make laws, provided that in any manner with respect to which the legislature of a state and the parliament have power to make laws, the executive power of the state shall be subject to and limited to the executive power expressly conferred by this constitution or by any law made by parliament upon the union or authorities thereof. So we have a rule making power, my lord, that is legislative in the field, my lord, but so to that extent, my lord, we have executive powers also. So our administrative instruction, that notification of 2003 prescribing regulations, my lord, is saved by not only, my lord, that judgments, these judgments, my lord, but also Article 162, my lord. And that regulation, my lord, itself says, that regulation itself says, my lord, I have annexed a copy in the first item number 1 in my affidavit at clause 17. The regulation itself says any type of stone entering or leaving the premises of 5052 WPC, my lord, my affidavit, page number 76, my lord, the regulation starts. Page 76, regulation starts, my lord. Internal page 8. It is 29/1/2003. The governor of Assam is pleased to issue guidelines for installation of a stone crushing machine identified as stone crusher within the state. Consequent on issue of the guidelines, no stone crusher shall be installed in the state without obtaining a permit from the government in the forest department. And one of the, my lord, clauses of that guideline at serial number 17 17 says at page 77, my lord.
This I marked. Then
Yes, ma'am.
you-
Coming and in fact going out of stone crusher unit, my lord, transit permit and transit challan duly issued under the are required. Now, my lord, what has happened after this writ petition, my lord, we could find that, my lord, the petitioner was operating without, my lord, there being any permit under this 2003 notification, my lord. So item number 4, my lord, 6544/2022, what they have done now, besides challenging the closure notice, they have also challenged this regulation, which is as old as of, my lord, 20, which was issued 20 years back, my lord. If my lord peruses the prayer in the writ petition, item 4. Prayer is at page, my lord, 36. Now that item number 4, page 36, my lord, is the prayer.
Item 4 is WBC 4839.
Oh, sorry, my lord. I'm following the yesterday's list. 6544.
6544.
Rakesh Kumar Singh, my lord. Iman has it. 6544, prayer at page 36. Since, my lord, in the meantime, that guideline came in their way, my lord. Now, after 20 years, they have challenged it, my lord.
You are arguing a stopper against challenge.
There is no challenge, but not to, there is a principle called stairs assessment, my lord, not to unsettle a settled provision. That's why I'm bringing in that delay statement. All are following this guideline for last 20 years, madam. If this is interfered at this stage, my lord, all cursor units will, my lord, run freely, madam. Out of our control. It first prayer, my lord, a writ in the nature of certiorari shall not be issued, setting aside causing the impugnment. That's the notification, my lord, guideline for stone crusher unit. Then, because they are not registered under that guideline, we issued a show cause notice that is challenged in the second prayer B. Show cause notice they replied, which was found not satisfactory, my lord. Their meal was closed. That is prayer number C, my lord. So, if I may now take your lordship to page 79 of the writ petition, my lord. Page 79, my lord.
Just a minute.
My lord.
Page
79, my lord, Annexer 12.
yes.
It was a so-called notice from the DFO to the petitioner, my lord. It says, by office order number of the undersigned as referred above, it was intimated that no stone crusher unit within Dibrugarh division shall be allowed to operate without the fulfillment of the conditions laid down on the government notification number so and so dated 29/1/2003, that regulation, my lord. It has come to the notice of the undersigned that RK Stone Mills under the partnership of you has been operating without a valid license as evident from the offense report number so and so of Jaipur Ranch, where 2 vehicles had been seized in connection with transporting materials without transit pass. You are already so called as to why you have been running the stone crusher unit without obtaining license. Your reply should reach within so and so. To which the petitioner replied, at my lord, paragraph page 81, my lord, referred to a judgment which has no connection with this rule 23C, my lord. Then the order impugned is at page 83, my lord. Last paragraph, whereas without having a valid license and the mandated documents as per guidelines issued by the government of Assam in 2003 by notification number so and so, that it is evident that so and so is in violation of 63 and 64 of minor mineral concession rules. Consequent upon the above, the Divisional Forest Surveyor Dibrugarh Region do hereby order closure. So now closure is challenged only on the ground that that regulation is invalid, my lord. Now, my lord, last submission would be, my lord, one argument may come, my lord, that a 2003 regulation guideline, which is prior in point of time, then 2013, how that can survive or how that can be saved by a subsequent, my lord, rules of 2013. So for that, my lord, Kumar Stone Crusher, because my lord, I have till now I have indicated, my lord, that stone is a forest produce in terms of Assam Forest Regulations 1891. The judgments of the Honorable Apex Courts also said that it's a forest produce. And at the same time, my lord, stone is a minor mineral. So to the extent, my lord, it is a mineral, its control is also vested upon the state government. And to the extent it's a forest produce, my lord, it is also by the forest department. If we say that 2013 3 regulation, it doesn't mention about any, my lord, traceable source of power. So we can fall back to, my lord, both the forest regulations 1891 and the 2013 concession rules. The same issue came up before the Honorable Supreme Court in the Kumar Stone Crusher case, my lord. There was a challenge to that, my lord, since MMDR Act of 1957 has already been enacted. This pre-constitutional law of 1891 cannot be saved under Article 372. 372. So that Kumar Stone Crusher judgment, my lord, finds at page 53 of my written argument, my lord. Paragraph 8 of that judgment, my lord, at page 70. There are so many issues clubbed, my lord, and finally decided. Paragraph 8, my lord.
Page,
Page will be, my lord, 70 of my written argument, 70.
please give me the para again.
Paragraph 8, my lord, at page 70 of my written argument.
Yes,
MS Kumau Stone Crusher filed a writ petition praying for quashing the order dated 14/6/1999 issued by the Conservator of Forest and order dated 1/6/1999 issued by the Divisional Forest Officer directing for making recovery and levy of transit fee upon the finished item of stone, that is stone grids, stone chips, etc. from the writ petitioner. The petitioner's case was that its stone crusher, which collects the boulders from the bank of Sardar River, which is a forest produce, transit fee is charged and paid. After taking the boulders to the crushing center and involving manufacturing process, boulders are converted into commercial commodity, namely stone grids and chips. It is pleaded that after it becomes a commercial commodity, it ceases to be as a forest produce, and no transit fee can be charged and recovered thereafter. Paragraph 10, my lord. The writ petitioners proprietary firms were carrying on the business of manufacturing and sale of finished produce of washed and single pea gravel and bajri. The writ petitioners used to purchase riverbed material from the lease of quarry on payment of royalty and trade tax on which transit fee is charged by the state of Uttarakhand. But when the writ petitioners transport their finished product from their factory to consumers, transit fee is charged by the state of Uttarakhand, and further, when it crosses the border of Uttarakhand and enters into the state of UP, the transit fee issued by the state of Uttarakhand is to be surrendered, and again, transit fee are to be taken by making payment of the transit fee. 11, my lord. The High Court allowed the writ petition by its judgment dated 30/3/2005, holding that after riverbed material is converted into washed and single pea gravel and bajri after involving manufacturing process, a new commercial commodity comes into existence and same cease to be a forest produce. The High Court allowed the writ petition holding that no transit fee can be realized. It was further observed that even if same is treated as forest produce, transit fee cannot be realized twice on the same material under the 1987 rules. Both the state of UP and Uttarakhand have filed civil appeals against the aforesaid judgment. Paragraph 14, my lord. The writ petitioner pleaded that since royalty and other charges are being paid in accordance with the minor mineral rules framed under the Mines and Mineral Development and Regulation Act 1957, hereinafter referred to as the MMDR Act 1957, no transit fee can be levied on the petitioner. The High Court allowed the writ petition holding that transit fee under the 1978 rules cannot be applicable on transit of minor mineral. The levy of transit fee was held to be illegal. So among other writ petitions, this was one of the issue, my lord. At paragraph 26 now, my lord. Paragraph 26, my lord. 26.1. This represents the petitioners who have obtained mining leases. This is another category of petitioners, my lord. This represents the petitioner who have obtained mining leases under the UP Minor Mineral Concession Rules 1963, as well as leases of major minerals for mining of various minerals. Some of the mining leaseholders are also transporting the minerals. There are other categories of petitioners who are only transporting the minerals from their factories. Stone crusher dealer who are crushing the minerals and transporting finished minerals, All these petitioners denied their liability to pay transit fee. The petitioners claim that the stone ballast and grid, boulders, etc. are minerals which are covered under the MMDR Act 1957, and no transit fee can be charged under 1978 rules. Some of the petitioners say that they are transporting the minerals through the state and national highway by paying toll tax. The petitioners further state that the transit fee is charged twice. This is on raw material as well as on finished goods, which is not permissible. Checkposts have been put on state and national highways, which is illegal. These were the case, my lord, before the Honorable Apex Court. Then, my lord, one of the issue raised therein was regarding paragraph 60 and 63, my lord have already seen, my lord. Finally, Honorable Apex Court said that whatever may be the form, it retains this character of stone, my lord. Paragraph 79, my lord, is page 94. Paragraph 79 at page 94.
Yes.
The Forest Act 1927 and the MMDR Act 1957. My lord, just from my side, my lord, the Forest Act 1927 is perimeter to Assam Forest Regulations 1891. Assam Forest Regulation is meant for Assam, my lord, and this is for the rest of the country. We now proceed to consider the impact of 1957 Act on the Forest Act 1927 and the Transit Fee Rules 1978 framed under Section 41 of the 1927 Act. The Forest Act 1927 is a pre-constitutional legislation enacted by the Indian legislature as per Section 63 of the Government of India Act 1915. The 1927 Act was the law enforced in the territory of India immediately before the commencement of the Constitution by virtue of Article 372 of the Constitution of India. The 1927 Act continues in force until altered and repealed by a competent legislation. The 1927 Act was enacted to consolidate the law relating to forest, for transit of forest produce and duty leviable on the timber and other forest produce. The 1957 Act was enacted for regulation of mines and development of minerals under the control of the Union of India. So there's a subtle difference, my lord. 27 Act, the Forest Act is, well, it says it relates to law, consolidating law relating to forest, transit of forest produce and duty leviable on timber, on forest produce. Whereas, my lord, 57 Act, my lord, is for regulation of mines and development of minerals under the control of India, Union of India. The 1957 Act was enacted under Entry 7, Schedule 7, Entry 1, List 54 of the Constitution, which is to be the following effect. My lord, I will not trouble your lordship with the entire judgment, my lord, because it is in good order judgment of paragraph 119, my lord. At page 106, my lord.
Yes.
Because it was in the context, my lord, that definition of forest produce, my lord, stone. My lord, it says, my lord, this was on the issue of, my lord, definition as it says, my lord, when found in or brought from a forest.
Brought from a forest.
Yes, my lord.
Okay.
in that context, my lord, that because that was a point raised earlier also, my lord. 119. The word from is used to denote a point of time, a place, or a period. Both the words found in or bought from have been used before the word forest. Both the words that is found in and brought from have clear nexus with forest. The true meaning of the word brought from has to be appreciated when read in the context of the word found in. The words brought from is an expression which conveys the idea of the items having their origin in the forest and they have been taken out of the forest, from the forest. The word from refers to the place from which the goods have been moved out and is from the place of their origin location. The forest is birthplace. The origin of the item mentioned in para 1 to 4 of subclause B of section 2.4. The word found in mean that the item which has origin from the forest is found in the forest, while brought from means that items having origin in the forest have moved out from the forest. So after discussing everything, my lord, the Honorable Apex Court taken note of that, my lord, T.N. Godavaran judgment at paragraph 125, my lord. One 25.
Yes.
The Forest Conservation Act 1980 is another parliamentary enactment which has been specifically enacted to provide for the conservation of the forest and for matters connected therewith. The definition of forest cannot be confined only to reserve forests, village forests, and protected villages, forests, as enumerated in 1927 Act. This code has already held in T.N. Godavaram versus Union of India that the word forest must be understood according to its dictionary meaning. In paragraph 4 of the following is stated. The word forest must be understood according to its dictionary meaning. The description covers all statutorily recognized forests, whether designated or as reserved, protected, or otherwise, or for the purpose of section 1 of the Forest Conservation Act. The term forest land occurring in section 2 will not only include forest as understood in the dictionary sense, but also any area recorded as forest in the government record, irrespective of the ownership. This is how it has to be understood for the purpose of section 2 of the Act. The provisions enacted in the Forest Conservation Act 1980 for the conservation of the forest and matters connected therewith must apply clearly to all forests as understood, irrespective of the ownership and classification thereof. 126, my lord. Thus, forests shall also include all statutorily recognized forests, whether designated as reserved, protected, or otherwise. The term forest land occurring in section 2 will not only include forests as understood in the dictionary sense, but also any area recorded as forest in the government records, irrespective of the ownership. Restrictive meaning of forest as given by the Uttarakhand High Court in MS Gupta Builders cannot be approved. This is relevant to note that even before this court's definition in T.N. Godavaram case, in an expensive manner, the forest was understood by the state legislature as in a very wide manner. This is reflected in the definition of the forest and forest land given in so and so Act. For example, my lord, somebody is allowed to bring out boulders from a riverbed. That cannot be a revenue land, my lord. That cannot be a revenue land. I will directly take your lordship to the ratio of this judgment, my lord. At the end of the judgment, at paragraph 215 at page 143, my lord.
Please, we'll have to take it up some other day.
My lord.
Para
215, my lord.
215. Yes.
It says, my lord, the conclusions, in view of the foregoing discussion, we arrived at the following conclusions. 215 1A, the crushing of stones, stone boulders into stone grids, stone chips, and stone dust does not result into a new commodity different from forest produce. The crushed material continue to be stone and retain their nature of forest produce. Nature of forest produce, my lord. It's too late in the day to say it's not a forest produce stone, my lord. B, coal, which with its various varieties, limestone, hydrate lime, quick limestone, slack lime, veneer, and plywood waste are all forest produce. Then, my lord, 2152, my lord. Marble 2151C is also relevant, my lord. Marble blocks, marble slabs, marble chips are all forest produce. Fly ash, chinker, synthetic gypsum are not forest produce. Gypsum, however, is a forest produce. 215.2. The Forest Act 1927 and the rules framed under Section 41 are neither overridden nor impliedly repealed, altered, or amended by the Mines and Mineral Development and Regulation Act 1957 and the rules framed thereunder. Both the above legislation operates in different spheres of field. 215.3. The word brought from, as occurred in Section 224B of the 1927 Act, mean brought from forest where the forest produce has originated. The words brought from forest cannot be read as brought from forest. We, however, clarify that
Brought through.
brought through forest. We, however, clarify that for an item to be treated as forest produce, its origin may be in any forest within the state of MP or in a forest outside the state of MP. The forest has to be understood according to its dictionary meaning, which covers the statutorily recognized forest and also include any area regarded as forest in the government record, irrespective of the ownership. The meaning of forest cannot be restricted only to reserve forest, protected forest, and village forest. So, both these acts survive. So, if our regulation is not saved by 2013 concession rules, then it is saved by the Assam Forest Regulations. Additionally, my lord, 2013 concession rules were framed under Section 15 and 23C of the MMDR Act. So even if 2013 rule was not framed, 2020 Section 23C was always there, which gives us power to frame a rule for regulating illegal mining, transportation, and storage. That was always there, man. So that regulation, our guideline is saved by that act, that section also, man.
We're fixing it on 17th. Mr. G. N. Saira, Senior Counsel, assisted by Mr. M. Saira, Counsel for the petitioners, is present. The submission of Mr. P. N. Keshav, the Additional Advocate General, remains inconclusive. List again on 14.
16.
17/8/2023. Is there an election tonight? Well, now I have field work.
Field work. My lord, batted in 3 format, now fielding, my lord.
This of the 15th program that of this 10 and all everything is coming up.
This time it will be held in Lota Hill, my lord, not in the old building. Old building.
Old building. Structure has come up. This time we expedited thinking that there will be rains. So because the field has to be protected, otherwise
Yes.
lawyers and guests, they can't come in. They will be damp. So, but this whether we don't know what would happen on 15th. Very unpredictable
Old building, that's almost concrete, my lord, that road part. Old building, road part is almost concrete, my lord.
No, that is concrete, but wherever you will come and sit,
Yes.
if that is damp, you will be uncomfortable there. So let's see.
Item number 5 for orders.
Apply, sir.
Pardon me? Monday, yes. Monday. The peer, MH Chaudhary. Consider the question. Can it go to 16th? Because there is some logistic problem. They will not be able to send the record because by the time they will type it out and I'll sign, by the time Monday it will not come. 16th.
Six.
Yes.
One small correction in the order of system that we will still order. You know, it takes up the IA at page 11 bucket. To pass an interim order in favor of the petitioner. Only the category should be SC.
Page?
Page 11 of the IA lordship.
Yes,
Point number 6 lordship.
it should be a C.
It should be SC.
Para 6. STA. Should write SC. SC. I forgot your name. Mr. A. Chakrabarti.
1 and 2.
Mr. M. Das for petitioner. I'm sorry, I'm so forgetful with names. Yes.
Same.
Black to বন্ধ করে দিয়া। Black to